that's good enough. Sure. Agree.
Right. If you want, I mean,
No.
we can.
No,
All
we
right,
are in live.
we're good.
Okay.
It's live. Now we gotta wait for a little minute. Yep, we're good.
Okay. So this is recording.
Yep,
Okay. So we have audio, we have video and sound now.
yep.
Okay. Now, as far as the pictures,
158.
how are we gonna?
No, we're good. Everything, we're not doing OPAC. Everything.
Okay, oh,
the
so you can
pictures
do it all
will
through
be-
this?
Yeah, the pictures will be on the screen.
Okay.
Who's gonna hand the orders to me? Because there's no
The
way-
lady, Charlene.
Where is the lady? Because I haven't seen
I'll
anybody here.
call her.
All right, get her now. Let's go.
How we know this recording? The audio is what?
Because it's showing here. Did you turn on this?
Yeah.
That's how we know. Why, you can't hear it? Hello? Oh, the mic's not on? Okay, trying. The other one. The other one. Hello? You have it plugged in. This is not plugged in. Hello, testing 1, 2, 3.
That one is not working, but it's in live, so.
It's not working because we need this one. All right, try it again. Testing 1, 2, 3.
We don't have any audio.
We need to go to the.
We should have audio.
Why do you need, listen, why do you need audio here? This person does not speak. Why do you need audio here? This is the lady that hands the orders normally. Why do you need audio here?
Oh, no, I was just testing it.
Okay.
Everything is good
We
here.
can get like I said, just a tape recorder from the clerk's office. I'm sure they have one. Just a regular mini tape recorder. We stick it up front. That's what we got to do.
The audio is showing fine here. Let me call the clerk.
Yeah, let's make sure that we have audio.
Go get Charlene.
I don't see that here.
Nothing had to be turned on.
There's usually an IT, yeah, no, that's very important. There's usually, I remember, listen, God, I'm old enough. I remember the days when somebody would turn on a, cassette recorder, one of those large, Marantz or Sony things, and that, and that was that wasn't that long ago, no. But it was more reliable, it seems, than all these series of interfaces,
Understood.
But
So, y ahora.
I just what I was going to tell them procedurally was, if you can't show the evidence, and you're right, if they want to go through each thing, which I've never seen here, but if they want to go through each thing individually, that's fine. But I said otherwise, if you don't want to do that, we'll hear the defaults, and all those other cases will be continued.
No, don't worry. It's recording.
But
Correct.
Yeah, it's good.
right. So you just can't,
Close that.
you can't say you've got a computer, you could have looked at it online.
No.
Yeah, it's connected, but I don't see any.
But
Okay, we are live.
you'll hand me the orders, right? As we get.
We have audio? Yes. And it is recording. Okay?
Okay, are we ready to proceed?
Yes, Mr. Magistrate. We are live, we are recording, and we have audio.
Okay,
Thank you for your patience.
thank you.
Hi, it's Mary. Everything is
Okay.
okay. We have audio and video.
Okay, we're gonna start.
Caprione?
Good morning, everybody. I'd like to call the Code Enforcement Special Magistrate hearing to order here in the town of Pembroke Park, Wednesday, March 16th. Sorry we're a little late, had some technical difficulties. I'm going to give a brief opening statement. Thank you for being here today. Welcome. Please turn off any cell phones. Please note no weapons of any kind are allowed in the chambers or anywhere in the facilities. All issues that come before us, we ask that everyone show mutual respect, listening quietly. Please refrain from clapping, heckling, verbal outbursts. The hearings are conducted by the special magistrate. The purpose is which to give the alleged violators the opportunity to contest the decision of code enforcement which resulted in issuance of the violation. The hearings are conducted in a quasi-judicial manner. I am the special magistrate assigned to hear today's cases. I act much like a judge in a court, that is to hear cases presented by code enforcement officers, to hear contradictory arguments presented by the alleged violators. Hearings are open to the public. All persons who testify as to facts must be placed under oath, including code enforcement officers. The hearings are not conducted in accordance with the formal rules of evidence. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of a common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. Documentary evidence cannot be considered unless the alleged violator or code enforcement submits a copy through a hearing file. Each party has a right to call and examine witnesses, introduce exhibits, cross-examine witnesses on any matter relevant, and to impeach witnesses against him or her, and to rebut evidence against him or her. It is the responsibility of the magistrate to make findings based on the evidence of record. The fact-finding determinations are limited to whether the alleged violation occurred or not. If so, whether the persons named in the civil violation notice can be held responsible for the violations. I may also modify the decision of the code enforcement officer as to the time for correction contained in the violation notice, even though the time is rebuttably presumed to have been reasonable. I have the authority to assess and order the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find that there is substantial competent evidence that the named violators were responsible for violation of the relevant code sections as charged. If I affirm the decision of the code inspector or officer, the order will specify the amount of the civil penalty, administrative costs of a hearing, which are $100 flat, the date by which the violation must be corrected, to present resumption of continuing violation penalties, I'm in a hearing, I can't speak now, sorry. The date by which a violation must be corrected to prevent resumption of continuing violation penalties, if any. Any aggrieved party, including the city, may appeal the final order of the master or the magistrate to the Circuit Court of Appeals. Such appeal is not a new hearing, but is limited to a review of the record created by the special master. It has to be filed within 30 calendar days of the issuance of the order. If you are found guilty of the civil violation charge, the administrative fee is $100. City representatives will present their case first. The alleged violators will present their case thereafter. I will consider the evidence and render a decision after all arguments are heard. Thank you. Roll call, special magistrate present. Who else is present from city?
Chief Code Enforcement Officer Jocelyn Ramirez, present.
Code Enforcement Officer ERIK RICHWAGEN, present.
Marie Curry, Code Clerk.
Charlene, receptionist.
Okay. Are there any minutes to be adopted? I don't think so today.
No.
Okay. Can we please have a swearing in of anyone who will testify? Anybody who will testify at all, please raise your right hand. Anybody, if you're going to testify, you have to be sworn in. Affirm that the testimony you will give is the truth and nothing but the truth, so help you God. Say, I do.
I do.
Thank you. Are there any changes in the agenda?
No.
Okay, let's proceed with the first case.
I'm sorry, Special Magistrate. I do have one case that I would like to postpone.
Okay.
That would be case 5377.
That's case number 7.7 on the agenda?
Yes.
Okay, so per the request of the town, that is postponed to a future date to be determined?
Right.
Okay. So that's removed from this agenda. Any others?
No.
Mr. Magistrate, if I may, for the record, Brian Sherman, Special Counsel for the city, for the town.
Thank you. Okay, we can proceed then with the agenda and start to hear the cases we have for today, please.
Okay. We have an attorney present, case 5771.
What number is that on the agenda?
7.15, and that's on page 3.
Okay, that's the case we're going to hear first.
Yes.
Okay, so let's hear case 7.15, case number 5771, E&M Properties, 2665 LLC, Sunshine Provisions, formal hearing. Sections of the code cited, BTR, permits, nuisances, second offense.
Okay. Chief Code Officer Jocelyn Ramirez, case 5771, property owner E&M Properties 2665 LLC, business Sunshine Provisions, site address 2641-2681 South Park Road, Pembroke Park, Florida. A notice of violation was handed to the business on April 26, 21, sent out by regular mail on April 29, 21. Notice of formal hearing with a copy of the notice of violation was sent out by certified mail on March 3rd, 22, and posted to the property on March 4th, 2022. The violations were for a repeat, and I have a copy of the previous order, case 4601, that considers this case a repeat violation.
Administrative notice is taken of the prior order, which is deemed admitted into the record. Go ahead.
For operating without a business tax license. And then did unpermitted work, combined warehouses 2641 through 2681 without a building permit. Installed electrical cameras, light fixtures, and AC replacement without a permit. There was odor nuisances coming out from the dumpster. This violation they have complied with. As far as the other items, no compliance has been met.
And you are aware of continuing existence, that is, a continuing lack of correction of the other violations of the
Yes.
of the citations that are charged.
Right. There hasn't been no reinspection, no follow-up from the tenant or property owner. And therefore, I'm recommending, since this has been open since April 26, 21, I'm recommending that they comply with everything in 30 days. If not, a $500 per diem.
Earlier order, which has been administratively noticed, did find that if they had another violation of this kind, that this could be treated as a repeat violation.
Yes.
Okay. Is there anything else you wish to say at this time?
No.
Sir, let me hear from you, your name and your relationship to the violator, and please then tell us what you have to say.
Morning, Mr. Special Master. Alan Rains Rains Legal on behalf of E&M Properties 2665 LLC, which is the owner of the property located at 2641 through 2649 South Park Road. There is a distinction between 2641 through 2649 South Park Road and 2665 through 2681, which I will get into in a minute. But these are two adjacent warehouse bays. My client, E&M Properties 2665 LLC, owns the bay to the north. Chickalee's Family LLC owns the bay to the south, and we previously leased that. We've ceased operations at both locations as of late November 2021. We're no longer operating there. Prior to November and subsequent to the violation notice in April of 2021, which found the properties to be in violation because there was a opening in the concrete block wall between the two properties. It was a meat processing plant where there was a cooler between the two properties that allowed them to walk through. That has been closed up. These properties have been bifurcated. My client leased the property to the south that's owned by Chickalee's Family LLC. We are no longer operating in that property. We have vacated. This case 5771 is for 5 items that does not distinguish between my client's property located at 2641 through 2649 and the property to the south, 2665 through 2681. So let me go down in order of these issues. The business tax license. My client bought this business, an asset purchase agreement for the business owned by Chickalee's Family LLC, and it had a business operating license for that. Subsequently, my client expanded to the space to the north. We acquired that warehouse, and there was an issue with code enforcement issues for certain improvements that needed to be made for both properties. That precluded the reissuance of the business tax license. That was the first issue. We could not bring the property into compliance, the north property that we own and the south property that we leased, into compliance without substantial improvements to the lease property. I can say that there was a dispute with the landlord with regard to those improvements. Ultimately, as I previously stated, we vacated the south portion. So it's my understanding that there may be a temporary business license that has been issued in connection with the compliance of the 40-year plan for the property that we own, which is 2641 to 2649. We need clarification on that. That is the first issue. The combined warehouses, it's my understanding that code enforcement has been out there and has verified that these properties have been separated. The third item, installed electrical cameras, light fixtures, and AC replacement without a permit. My understanding from Officer Ramirez's email correspondence from June 18th, there's been a permit pulled to correct the certificate of use violations, install exit signs, emergency lights, and label panels. That should bring the electrical issues that were at issue for my client's property at 2641 through 2649. I do not believe we have any additional responsibility for 2665 through 2681. That is now the responsibility of the owner of that property.
2665 through 2681.
Is owned by Chickalee's Family LLC.
At the time of these violations,
Right, he's talking about the property next door, but this case is not stating that. This case's site address is 2641 South Park Road. What they did is combined 2641 through 2681. So the property that they own is 2641 and 2649. It's split into two. So what they did was combine it to the property next door that they do not own. But we're not discussing that here. We're only discussing that the reason I have to separate these two cases, there's two cases. There's 5771 and 5770 for that particular reason, because they're two folio numbers. So,
and again, I'm going to oversimplify, and excuse me for doing that, but that sometimes works in, with convoluted facts. So are you stating to me that these violations have to do with the north portion of the property, the northern section, which is owned by this respondent?
correct.
Okay, that's what you're saying?
Yes,
So these violations are all attributable to that?
right.
Okay, so bearing that in mind, and because that's been stated by the code enforcement officer, that these are attributable to the northern part of the property, what are your arguments about these violations then, forgetting the south for a moment, because I imagine that you're not going to be representing them on the south portion?
Correct.
So what are your arguments being clarified that this has to do with
So
the owner you represent?
the only thing I would like to point out is the case overview, the site address provides 2641 through 2681. Notwithstanding that, and based on the statement of Officer Ramirez, the first violation, operating without a business tax license, we're in compliance because we're no longer operating there. That stopped in
Okay,
November.
but there hasn't been any reinspection. Nobody has called to let me know that the business was no longer operating, as you said, as November 21. So can somebody call a reinspection so I can go out to the property, take a look, what's going on there? Because no communication has been going on with your client.
Absolutely. We, as recently as yesterday, and I believe CJM Construction has been in contact with Officer Ramirez. They are completing the improvements for the 40-year inspection, and they have already submitted a change of contractor, and they are submitting a change of contractor for the open permits to complete the electrical work. And I believe they should be in touch as late as today, and we believe that those issues will be corrected within 60 days to complete all of these issues.
I got a phone call yesterday from a permit technician who was inquiring about the cases. That's all I got.
Okay, I believe I wasn't copied on the email, but I did see it from CJM Construction. They've already done a change of contractor for the 40-year inspection work. That's a different case number, and then they are going to be substituting in through a change of contractor to complete the electrical work to bring my client's property into full compliance. They will also call in the inspection to verify the bifurcation of the warehouse, and I have Mr. David here, one of the principals of my client, that can testify that they ceased operations in November, and we would welcome an inspection by Officer Ramirez to confirm we're no longer operating, and to address item 2, that the warehouses have been bifurcated and they are no longer open between the two.
Well, I know that, I believe, correct me if I'm wrong, but standard practice is that the reinspection is requested by the violator, and the
Right.
code officer has to be able to view and confirm these conditions that you're stating, because that is standard practice.
We have one correction. There was a prior inspection that was to address the electrical work, and to my understanding, the inspector was also there to verify the bifurcation at that time. The inspector, at least from my understanding, and Mr. David can verify, I'm going to butcher the name, but Manar, her last name escapes me, Manar Amira would arrange for an inspection of the electrical permit. The inspector showed up and said he wasn't going to do the inspection because the electrician was not present. That's when we ultimately made the decision to switch to CJM Construction, that's going to handle closing out this permit and handle any electrical work that needs to be done. So I believe it was called in for the inspection with regard to the bifurcation along with the electrical work, but that inspection was not completed because the electrician was not present.
Is it normal to have the electrician present during the electrical inspection? I thought it
Yes,
was. Yes,
because they
So
have to
that-
complete the permits in order for it to be cured, the violation to be cured.
Right, so that's not attributable, to the town. There's multiple violations here, so,
So let-
you,
And
Yeah.
going to the third issue, the electrical cameras, light fixtures, AC replacement, that is the subject of the electrical permit. The AC replacement was not a replacement, it was a repair. We believe that the light fixtures and cameras are going to be addressed by the issued permit that's going to be taken over by CJM Construction. And the fourth issue, the odor nuisances, Officer Ramirez noted that that has been complied with.
right, that's not an issue.
And then the double permit fee assessed is 5, but I believe we're really only here just to verify that 2641 through, the two warehouses have been separated correctly. We will immediately request a reinspection on that. And then 3, we're going to have CJM Construction substitute in as the contractor of record for that permit and be there, request the inspection and be there for the electrical inspection on these issues. And then we believe that my client's property will be brought into compliance at that time.
Okay, the compliance will be met when all those permits are completed, when all final inspections are done and the permit's complete and the permit's closed.
Understood, and that's why we're bringing in CJM Construction. We believe we're in position to address all these items. My client can testify we're no longer operating. We welcome the inspection to show that. Welcome the inspection to show that these have been bifurcated. We would request 60 days to achieve final inspection and compliance. We believe we're going to get it done within 30, but in abundance of caution, we would request 60 days.
And I normally am mindful of requests for reasonable extensions, but I want to ask the town, because this has been pending since April of '21.
Right, and because it's a repeat violation, I'm sticking with the 30 days.
Based,
Respectfully request 45. We want to make sure that we're not back in front of the magistrate again, and that these issues are concluded, and we're bringing in the right team to get this done, and we want compliance, and to ultimately, the property's been listed for sale. We can't sell it until it's in compliance. We're very motivated. We want to get this done.
To me, it is a repeat violation. I think the issue about the property ownership has been satisfied to my, any inquiry I had. Certain violations still exist. They are repeat violations. I just want to ask, the trades is, I want to be, this is a repeat violator, and this does go back a year, more or less. Is for the work that's to be done, is 30 days too tight, or is 45 days warranted? Because if it is, I'm inclined to give the 45 days.
I would give the 30 days, and they can, if they can't complete it in 30 days, they can always have the option to mitigate the fines.
What?
Mitigate the fines.
Is something that, in your professional opinion, can be done within 30 days?
I mean, they had almost a year to get it done.
We just engaged a new contractor.
Right, but that's, again, that's not attributable to the town. I'm mindful of what you're saying, but again, there's been multiple violations here. It's a year.
The only thing I would point out to the special master, there was an issue as to who was going to prepare what, or repair what, or fix what when these properties were.
No, I understand, and you bifurcated it, and there's another owner on another case now, and you've ceased operations, but it doesn't change the fact that there were multiple violations. There's a prior order, and it's been a year. So I've heard the evidence. I've listened to your argument. I think in light of the totality of it all, I do find that there is a violation of the garbage-related nuisance as to BTR, as to the electrical permits, as to the other violations that occurred. It is a repeat violation based on the prior order. I'll give 30 days for correction because it is a repeat violation per the town code. That is $500. So please be diligent so you can do it in time. Thank you for coming in. That is the order.
Mr. Magistrate, if I can add just one thing for the record as well. Under Chapter 162, actually, the town doesn't even have to give it reasonable time to comply when it's a repeat violation. So the town could actually, could have requested the fine back starting from the notice of violation and opted not to do that. So as far as a reasonable time to comply, understanding that your order, but just to back it up further, that a reasonable time to comply when a repeat violation is found is not under a repeat violation is not guaranteed.
Oh, and thank you for reminding me of that in 162. That's an excellent point, Counsel. And as we have found that this is a repeat violation, the 30 days period, whether it's, under the circumstances palatable or not, really doesn't matter because the town could have given 0 or 10 days. So 30 days it is. Thank you for coming in, and good luck with please getting this done on a timely fashion because the intent is compliance.
We're moving
Fine.
forward forthwith.
Did you, I just didn't miss it. I'm sorry. Did you announce a fine?
Oh, yes, I believe I did. The fine is, all right. The order, I thought I said it, the order provides for compliance within 30 days. If not, the fine is a repeat violator is $500 per diem. And as always, there's just a $100 flat fee for any heard case.
Thank you.
That's the order. And the order will either be mailed to you, or if you want to receive a copy of it now, you must remain and the town must tender a copy of it now.
But Charlene will hand you a copy.
Thank you.
It has to be certified first. You need to certify the order first.
What do you mean?
What I mean is at the bottom of the order, it says that you certified it as a chief code enforcement officer.
Oh, no, that's for the certificate of service, that's when we send it out
Only
by
for-
certified
only-
mail.
Only for, one- okay, all
Yeah.
right, all right. Okay. Let's go ahead to the next case.
Next case is 6302.
If it's not too much trouble, just refer to the agenda number because.
Okay, yeah, yes.
Good morning.
That's the last page, page 4, and that's item 11.2.
Thank you.
Chief Code Officer Jocelyn Ramirez, case 6302, property owner
Oh,
Crosswinds at County Line LLC, site address 5525 Southwest 41st Street, Pembroke Park, Florida. This matter is here today for hearing to abate fine. A notice of hearing to abate fine was sent out by certified mail on March 3rd, 2022, posted to the property on March 4th, 2022. And we're here to abate a fine of $28,100. My recommendation is to abate this fine, to reduce it to 15% of the per diem fine. The per diem fine is $28,000. So 15% reduction of that fine is $4,200, and plus the administration fee would be a total of $4,300.
that's the town's recommendation?
Yes.
Is there anything you want to add at this time?
No.
Sir, you are your name, your address, your relationship to the property, and then please state if you're in concurrence with the town's recommendation.
Yes, good morning. Good morning, city officers, special counsel, Mr. Magistrate, city staff. My name is Neil Lechner. I'm an attorney in Hallandale. I'm here representing the owner, Crosswinds at County Line LLC. To try to save some time, do you mind if I take 1 second and speak to my client who's sitting in the back and see if he's amenable to the offered?
Right, it would certainly be wise that we can just briefly break for a moment, because if there is a concurrence, it would make this matter very short, and if there's not, then the order will provide whatever it may provide. The mitigation could be some, none, you know, we don't know, because we would have to have a hearing on that.
Understood. So,
As opposed to whether, if your client concurs, to me, that would be like in effect, a settlement, and I would enter it at that amount.
so with that being said, do I have your permission to walk back and speak to my client for a second?
Yes, very briefly.
Thank you very much. My client concurs. I've done my job.
All right, your client concurs.
Thank you. Officer, thank you very much for your help.
Thank you. Based on the town representation, based on the concurrence of record of the respondents, Crosswinds County Line Inc., through their legal agent, the fine is abated to a total of $4,300. Normally, I provide for payment within 30 days. Is there some other time that,
Only if they request more time?
No, I think
Okay.
that's perfectly fine. That's more than enough.
all right, 30 days. Please note that it is standard on these orders that if you do not pay within 30 days the abated amount, that the fine will be reinstituted at the original amount and will continue to accrue. So please timely remit payment to the town within that period, so you can avoid that issue of having the original fine amount reinstated. You understand?
I do. Thank you, Mr. Magistrate.
Okay.
And thank you, Ms. Officer. Okay, and you'll send, like the previous case, you'll send that out by certified mail, I guess, the next 2 or
Or,
3 days?
actually, I think it's, I can't speak for the town, but I think they prefer to give it to you. If you just wait a moment, you can get the order right now.
Oh, that sounds great. Thank you very much. Might I be excused?
Yes, but don't leave without the order, please.
No. Very good. Thanks again.
Thank you.
Next case is on page 4, item 11.1.
Item 11.1.
Yes.
Item 11.1, case 6154. That's item 2250 Warehouse LLC.
Yes. Chief Code Officer Jocelyn Ramirez, case 6158, property owner 2250 Warehouse LLC, site address 250 Southwest 30th Avenue, Pembroke Park, Florida. This matter is here today for for a hearing to abate fine. A notice of hearing to abate fine was sent out by certified mail on March 3rd, 2022, and posted to the property on March 4th, 2022. It is the town's recommendation to abate this fine by 15% of the per diem fine. The per diem fine is $12,250. The reduction of 15% would be $1,837.50 plus the $100 administration fee would be a total of $1,937.50.
That is the town's recommendation.
Yep.
Do you have anything else you wish to add at this time?
Just that the property is in compliance. They did complete their 40-year inspection. And that's it.
Well, there needs to be, as we all know, and I'll remind anyone,
Yes.
there needs to be compliance in order to request mitigation. If you're not in compliance, there can be no mitigation case. heard.
Exactly.
It should not be on the agenda. You are, sir, your name, your relationship to the property, and please state, as I asked the prior person, if you're in agreement with this.
And good morning to everyone. I don't know the protocols here. My name is Oscar Asher Bromberg. I'm the representative of the family that owns the business. Here's my father.
They are here?
My father is here.
Yes, okay. Yes.
So thank you for the recommendation. I just want to understand, okay, why 15%? I really appreciate your help. I'm new here. I know the protocols. What I can just tell is that we had, since November 2020, we got a new tenant. This new tenant.
So you want to argue the case then, because? No, because that's, either you accept the amount or we're going to argue the case, which again will mean that the fine could be mitigated, might not be, or might be mitigated to a different amount.
Okay, so let me ask.
Why don't you do that?
So he accepts?
Okay. Thank you very much. The fine in this matter is mitigated to 15%, which is $1,937.50. This should be, just as a matter of practice, I tend to,
Can you repeat the amount one more time, please?
$1,937.50. Going forward, I think it's a better practice that you just round up to, a whole number.
Okay.
But I'll follow your recommendation. So the fine is abated to $1,937.50. $937.50 has to be paid within 30 days. I appreciate you coming in. Please note, as a standard for these mitigation orders, if you don't pay the reduced amount within the 30 days, that the original large amount will become reinstated. So I would encourage you to please pay the reduced amount within that time, please. You may stay and receive a copy of the order if you'd like. Thank you.
Thank you, and God bless you. Thank you.
Thank you. Thank you for coming in, sir.
Next case is 5770, that's on page 2. Item 7.14.
5770 on page 2, and that's Sicalisi Family LLC.
Yes. Chief Code Officer Jocelyn Ramirez, case 5770. Property owner, Sicalisi Family LLC. Tenant, Sunshine Provisions. Site address, 2665 South Park Road. Subject real property is 2665-2681 South Park Road. A notice of violation was handed to the tenant on April 26, 21. Sent out by regular mail on April 29, 2021. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on March 3rd, 22, and posted to the property on March 4th, 22. The violations were for Sunshine Provisions, operating without a business license, combining the warehouses 2641 through 2681 without a permit, installed electrical cameras, light fixtures without a permit. On this violation, I also stated the AC replacement, but we clarified that on case 5770 that it belongs to the property next door.
So you're not proceeding with that, and that's not included?
Right, correct.
You've removed that?
Yes.
Go ahead.
And the odor nuisances has been complied with for the notice, odor nuisances coming from the dumpster has been complied with.
Oh, this is the companion?
Yes, that's the
property,
companion.
The other, or whatever you want to call it, the
Well,
abutting,
no longer as of,
the abutting,
as what
the
they said.
nearby, the adjacent, all right, whatever, yes, I understand. Is there,
the property owner was in contact with me as of the photos, January 10, 22. They allowed me to do an inspection that the property was vacated by the tenant. So they are trying to comply with all the violations. And as you can see in the pictures, they just gutted the whole place, they just removed everything. They did a lot of work without a permit inside the building, and so they're going through a hardship right now for what just happened to them. So I'm willing to work with them. I'm gonna recommend that they get everything done within 60 days, and if not, $150 per diem with a $100 admin fee.
so your recommendation based on the facts and circumstances, as you know, in this matter, are 60 days with $150 per diem
Correct.
under the circumstances?
Yes.
Is there anything else you wish to say at this time?
No.
Please give your name, your address, your relationship to the property, and what you care to say about this case only.
Okay. Angel Chicalisi, and the property address is 2665 South Park Road and 2681 South Park Road. Unbeknownst to us, the first people that were here, he was our tenant, and apparently he was having problems with complying to all of the violations. And we had no idea what was going on, quite honestly. That is my fault as a owner of the property. But he did things that we were not aware of, and he moved out on us. He said, the attorney said November 21st, but they had paid their rent up until December 31st of 2021. We were in Texas at the time for the holidays. When we got back, it was like all of this. As soon as we found out what was going on, because they removed a lot of things from the property that belonged to us, we called the police. Our neighbor called the police on December 17th to verify that they were stripping all the air conditioning units off the roof. So as soon as we got back on January 4th, we called the officers in charge, and we asked them to do a courtesy inspection for us, which they, of course, did. And that's when all these pictures were taken. So we just want to get it right, because like he was saying, he can't sell his property. Well, we can't sell our property either because of all the damages that they did. So, of course, we want to make this right, and we're not going to have the same type of business that was in that building that caused all the problems, you know. So we're hoping that we can correct it and have maybe, you know, I don't know.
I don't know what we're gonna do with it, but as far as the wall, they stripped the bearing wall out to use as a pass-through. First of all, it's against the law to take a bearing wall out. They did it without anybody knowing they did it. Every time they did something illegal, I was either in a hospital or having an operation or something. They did everything underhanded. They claimed they did this, they did that. They didn't do any of the all the violations are on them. They did everything illegal. We didn't do anything illegal. If you can check our record, which Sterling needs, we always had permits when we did something. They're the ones that did everything illegal. Now we're trying to rectify it.
See, what happened was they bought the
Ma'am,
building
one second. Mr. Magistrate, if I may. Sir, can you please state your name and address for the record?
My name is Robert Chicalisi. Address is 1010 South Ocean Boulevard, Pompano Beach.
And you're the owner, also one of the owners of this property? Thank you.
What
My
happened
wife
was
and myself.
they bought the building next to us. They were supposed to, I don't know if this is relevant or not, but just so you get a clearer picture. They were intending to buy our building because that's where their business was, their meat business. So what they did was, unbeknownst to us, without permits, they put this big, huge hole in the wall so they could go from one building to the next. That was one of the reasons why they were not able to get a permit to work there, occupancy license. So that they closed up the wall. They paid me till the end of December. They moved out, and they left everything in shambles. And
Electric.
I mean, 2665 and 2681, they passed their 40-year, we passed our 40-year inspection. Their building did not pass the inspection, and they're trying to say that, you know, they didn't have any dealings with this violations, which we feel they...
No, I understand. I mean, again, we're here about your remaining portion. I understand what you're saying about how they impacted you, and I'm mindful of it. And I understand that, I do take note of the fact that based on your direct testimony and your personal knowledge, the tenants seem to have behaved or taken certain actions that were detrimental to your property. But I ask you this, in light of the city testimony of the violations that do exist on your property, the city has offered you, which I think is reasonable myself, but I want your opinion as to the time you need, 60 days to comply. It's 2 months. Do you feel that is sufficient? And if not, because if not, then you would face the reduced, but nevertheless, $150 per day fine, which would, recommendation, which I'm inclined to accept.
Even though they're responsible for all the damage, and without taking permits.
But, it's anything that happens on your property, as you know, or if not, let me, under code enforcement, the owner is responsible, even if a third party does it. That's the law.
Okay, of course, we'll
Because
agree.
counties and cities can't be running around it just doesn't operate that way, trying to figure out who did what. It's the owner, you're responsible for the property you own.
Of course, we'll agree to.
Could we pull a demo permit on the property?
Well, I can't be advising you about
Yes,
what
you have to
can
go
or
to the
can't do.
building department.
That's not,
Yeah.
you have
No,
to go to
we'll-
building.
we'll
It's not
comply,
certainly not
yeah.
my role.
Just comply right now.
That's, you have to explore with other, building officials or whatever.
Okay. So 60 days is more than gracious. We will comply with that.
All right. The order being entered in this case does find that there are violations attributable to whoever, but there are violations on this property as indicated by the evidence. They need to be corrected within 60 days. If not, there will be a $150 daily fine for those violations. After that time, if they have not been corrected, remember, you need reinspection to confirm that they've been corrected. And of course, there's also imposed the flat $100 fee for every case. That is what the order provides. You can get a copy of it now if you remain a moment. And I thank you for coming in, and I, appreciate what you've gone through, but, thank you for correcting it.
I just want to ask to be clear. Their building now is no longer part of our building.
Right, the town insofar as I certainly, again, can't respond to that. The town insofar as they care to, or you can ask questions of the town.
What
at
was
this
the
hearing.
question?
That their address is no longer, part of our address, because it seems like it's always been combined, the violations.
No, the addresses have not
It's
been
separate
combined.
now.
It's just, the violation is stating that they combined, but they have to prove with permits that they put the fire-rated wall back together, and it's sealed, completed with a permit.
Their responsibility to do that, is what you're saying.
That's a civil issue between you
All right,
and him, and you have to figure that out with an attorney, how you're gonna go about it.
okay, thank you.
Okay.
Good morning, Mr. Magistrate.
Good morning.
Page 3, agenda item 8.3, case number 6135. Property owner, sorry,
Hang on a minute. $6135, you said?
yes, sir.
Okay, you may go ahead.
I've been sworn in. I'm Code Officer Richwagen, representing the town of Pembroke Park. This is case number 6135. Property owner, DPT Group LLC. Site address, 3136 John P. Kersey Drive, Pembroke Park, Florida, 33009, Unit 1. The property was operating without a business tax receipt. There was a demolition of a wall that was done without a permit. There was machinery that was installed without an electrical permit. A notice of violation was issued on 8/9/2021, delivered by regular mail on 8/9/2021. Notice of formal hearing certified mail on 3/1/2022. Posted to property on 3/2/2022. I have spoken with, you are the property manager?
Yes, sir.
I've spoken with the property manager, Rick, on a few occasions. He's doing everything he can to comply. He advised me that the tenant that was staying there has been issued a eviction order that was posted on 3/7/2022 by BSO. And according to you, Rick, as of tomorrow, this tenant should be evicted. It is my recommendation, seeing as he has shown good faith in trying to do everything he can to comply, I would actually recommend the maximum of 120 days to comply with a fine of $50.
That is the town recommendation?
Yes, sir.
Is there anything else, officer, you would care to say at this time?
No, that concludes my testimony.
Okay, sir, you are, your name, your relationship to the property, your address, and then tell us what you want to say.
Yes, sir. Rick Chaples. I'm the construction manager for the owner of the property, which is Kersey 3A3B LLC. And that, we say thank you to that offer because we have the eviction will be served and locked out tomorrow, and we'll start the process of getting permits to correct the issues that were caused by the tenant.
Okay, and in this case is 6135 DPT Group.
That's the tenant, sir. Yes,
That is the tenant of the property.
yes, sir.
That is it, okay, the owner of the property is,
Kersey 3A3B, I believe it's either LLC or LTD, I can't remember.
it's, I just want to establish this on the record with the officer. The owner of this property is, per county records, is Barn Fair Inc., Kersey Charles M. Lesser.
And that's confusing because we have a land lease with Barn Fair Inc., and I represent the Kelseys. I'm their construction manager.
Per the property owner, okay, so I believe, and I apologize for the confusion, but the town has gone by how this is listed in the county property appraiser records, which is what the law provides, which the owner is Barn Fair Inc., Kersey Charles M. Lesser. So again, per the county property records, confusing or not as it is, that seems to be the correct owner description.
The property owner, with the correction, is Barn Fair INC, Kersey Charles M. Lesser.
Yes, okay. So that's, again, that's just an aside of mine. I just wanted to be sure that the owner was accurately reflected. Confusing or not, that's how it's reflected in the county. If they want to change that, they have to change that. The town has nothing to do with that.
Yes, sir.
So, you will be given 120 days to comply, which is very generous. If not, there will be, and this is that fine recommendation, which again, I do follow the town recommendations, but I'm not bound by them. I can make my own. This is a first violation, because if there was a second violation, I would respectfully suggest this is too low.
This is the first violation, and as for the fine recommendation, due to the business tax receipt, instead of 50, I would recommend 100.
Okay, right, the 50 seemed a bit low. You'll have 120 days to comply, and if you have not complied within that very generous time, there will be a $100 per diem or per day fine until compliance is achieved. And of course, there is the flat $100 fee imposed for every hearing. That's what the order will provide here. If you remain, please, for a moment, you may get a copy of it.
Thank you.
And unless there's anything else that would take care of this matter.
Thank you very much, sir.
Thank you.
Is it okay if I collect all my final orders at the end? Because I have 7 of these things in front of you today.
You have 7 of these things.
Yes, sir. How would you like me to proceed?
Yes, he's next and next. We're gonna consistently hear his cases.
Well, that's fine. Then, you know, put these orders for this gentleman somewhere in a particular group so you can give them all to him at once. He has several cases. The town has to, you know, take note of that and act accordingly. Okay?
Next case is on page 2, item 7.11.
That's 5512, correct?
Yes. Chief Code Officer Jocelyn Ramirez, case 5512, property owner Barn Fair Inc., tenant Smoke Nation, site address 2500 South Park Road, Pembroke Park, Florida, Unit 2 and 3. Notice of violation was sent out by regular mail on January 14, 2021. A notice of formal hearing and a copy of the notice of violation was sent out certified mail March 3rd, 22, and posted to the property March 4th, 22. The violations were for operating without a business tax receipt. At this time, the tenant is in the process of obtaining the business tax receipt for Unit 2. And then another violation was the combination of Bay 2 and 3 without a permit, a building permit, alteration of electrical without a permit, and a loft without a permit. At this current time, the property owner tenant has obtained a permit for the combination of the bays, the alter electrical, and the loft. So the only item pending is the business tax receipt.
And you have confirmed that
Yes,
by your personal knowledge.
right. There's a permit number 2110942-0 that they have completed all final inspections. Therefore, my recommendations is to give them 30 days to complete all necessary paperwork for the business license, if not $100 per diem with a $100 admin fee.
$100 per diem. Okay.
$100 per diem, yeah.
Please repeat your name, your address, your relationship to the property, and tell us if there's anything additional that you wish to say.
Yes, sir. Rick Chapels, construction manager with the Kersey Group, management company for this property. You want my personal address or what address?
No, business address.
Business address, 1812 Southwest 31st Avenue, Pembroke Park, Florida, 33009. And I would like to say thank you.
All right, so you're in agreement with the recommendation?
Yes, sir.
Okay. Based on a concurrence that this will be disposed of in short order, I do find a violation of the BTR issue. As stated, there needs to be compliance within 30 days of the date of the hearing. If not, there will be a $100 per diem fine, plus the stipulated standard $100 fee for each case heard. That will be the order in this matter, which again, we're going to hold to give this gentleman all his orders at once.
Next case is 5500.
5500?
Yes. That's on page 2.
Okay. May proceed.
Chief Code Officer Jocelyn Ramirez, case 5500, property owner Hala, LLC, tenant TS Cabinets and Stones, Inc., site address 3125 John P. Kersey Drive, Pembroke Park, subject real property 3149 John P. Kersey Drive, Bay 4. A notice violation was sent out by regular mail on January 6, 2021. A notice of formal hearing and a copy of the notice of violation was sent out by certified mail March 3rd, 2022, and posted to the property on March 4th, 2022. The violations were for operating without a business tax receipt. At this current time, the tenant is in the process of obtaining his business tax receipt. I believe they're getting close to completing it. Therefore, I am going to recommend that they complete everything within 30 days. If not, $100 admin fee. $100 per diem and a $100 admin fee.
Sir, again, for the record, name, a business address, relationship to the property, and anything else you want to say.
Rick Chapels, construction manager for the property management company, the Kersey Group, and I am attempting to get everything finished with this tenant for this particular issue. They did have to pull an electrical permit, which unfortunately failed their first inspection yesterday. So the 30 days may be a little tight, but in light of everything else, I'll say thank you.
Okay, the order will provide compliance within 30 days. If not, there will be, as recommended by the town, which recommendation I accept, $100 per diem, and of course, the standard $100 admin fee. So that is what the order will provide in this matter. And again, all these orders will be aggregated for you to take when your cases are done.
Thank you, sir.
Thank you. Doesn't have any more?
Yeah,
He does have more?
they have 7 cases.
That's 7. Okay, I see. Under a different name.
Next case is on page 2. And it's case 5544.
Five 44, yes, thank you. Thank you.
Chief Code Officer Jocelyn Ramirez, case 5544. Property owner Hala, LLC, tenant Woods Professional Creative, LLC. Site address 3125 John P. Kersey Drive, Pembroke Park, Florida. Site subject real property 3149 John P. Kersey Drive, Bay 2 and 3. A notice of violation was sent out by regular mail on February 22nd, 21. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on March 3rd, 22, and posted to the property on March 4th, 22. The violations were for operating without a business tax receipt, and a tenant build-out done without permits. Bay 2 and 3 were combined without permits. At this current time, no permit has been obtained and no business tax receipt has been obtained for Unit 3, and no reinspection has been called in as of March 3rd, 2022. The property owner, manager, right, is here, and he has been in contact with me. He's gonna try to do everything to correct all these violations. My recommendation is to give them 30 days, since this has been ongoing for a year, and a $100 per diem fine with a $100 admin fee.
Anything else at this time, officer?
No.
Sir, again, you've heard what I've, I'm going to reiterate what I've asked you in the other cases.
Yes, sir.
Please respond.
Rick Chapels, construction manager for the Kersey Group Management Company for this particular building. This one I actually have some background on, so I did all the easy ones first, sir. So on this one, we got the notice, or the tenant technically got the notice back a year ago. And one of the challenges we had was one of the code changes which took place in the building code and in the fire code is any space over 2,500 square feet can no longer be a wood processing construction zone unless they have full fire sprinklers in the building. So that building at that time was not fire sprinkled. So the landlord, through myself, hired Wayne automatic fire sprinklers to the tune of $100,000. We added the fire sprinklers, which started in February of last year, February of 21. And that took until December 14th of 2021 to complete. The place where everything failed is standing in front of you because I failed to follow up with a tenant to make sure their BTR application was taking place after we got the place certified from code standpoint, from a building standpoint, being able to be used as a wood processing or a wood shop. They do cabinetry. So because they didn't apply for the BTR inspections, we are standing before you. So the 30 days, I will probably horribly miss. I would request as much as reasonable from you, if we can have more. And we have the architect completing the plans and hope to submit for a building permit sometime next week.
Oh, and I appreciate your candor and your accepting responsibility. My issue is that, I don't know, for what it's worth, I tend to view more substantially violations that involve building code, certification, fire codes. To me, those are the more serious violations. So I'm just going to ask the inspector one thing. In light of the one-year history, is 30 days doable in your opinion? Or is it just something that, because I'll just, in a nutshell, if it's not, my tendency is to split the baby, in other words, and give them 45.
45 sounds good.
The order's going to provide that you have 45 days, because again, this has been, I appreciate what you said, but at the end of the day, this is a serious violation that's been pending a year. You have 45 days to comply. I myself will not give any further extensions. If not, the fine, if there isn't compliance, will be the per diem of $100 plus the $100 standard admin fee. And that is what the order will provide. Thank you.
Next case is on page 2.
Okay.
Case, item 7.13.
Okay.
Chief Code Officer Jocelyn Ramirez, case 5639, property owner Hala LLC, tenant Hot Goldfish Corp, site address 3125 John P. Kersey Drive, Pembroke Park, Florida, Bay 2 and 4. A notice of
5539?
5639.
56, okay, yeah, okay.
That's on page 2,
Right,
7.
right, right. No, I just had the number wrong, that's all I got.
Okay.
Yeah. Okay, go ahead.
A notice of violation was sent out by regular mail on March 19, 21. A notice of formal hearing with a copy of the notice of violation was sent out certified mail March 3, 22, and posted to the property on March 4, 22. The violations were for an installation of spray booth without a permit, installation of rack system without a permit, tenant build-out without a permit, demolition of fire-rated wall and combination of bay 2 and 4 without a permit, installation of electrical camera system without a permit. The designated parking area was being blocked by a dumpster, and the waste dumpster has to be relocated. Prohibited outdoor storage. And those were all the items that were on the violation. At this current time, there is no prohibited outdoor storage. The dumpster is still on a parking zone area. There has been a permit application in process, number 93901, that was submitted as of August 2nd, 21. The application is in plan review, and no permit has been issued for commercial alteration.
I have a question
I mean,
about
I'm
that.
sorry.
How long, I mean, that's,
Can I offer?
I'm sorry. A permit has been issued for
Yeah, as of
commercial
yesterday.
okay, all right,
for removal of the door and closing, opening of between bay 2 and 4. A permit has been issued for removal of fire door and filled opening between tenant space bay 4. The permit number is 2211508-0. No other permits has been obtained as of those that I just mentioned. And again, the property manager is here. He has been in contact with me, and he's getting ready to finalize those permits. And so therefore, my recommendation is to give them 30 days, if not $100 per diem with a $100 admin fee.
Please reiterate what you have done in all the other cases and give
Yes, sir.
whatever explanation you have.
Yes, sir. Rick Chapels, construction manager for the Kersey Group Management Company for this particular facility. In this case, 2 facilities. So bays 2 and 4 were occupied with a former tenant who has since moved out and has relocated to a different building, not one of ours. But a lot of these things were resolved upon their leaving because they took their spray booth, they took their rack system, and et cetera and so on. Now, to certify all that for code and to take care of this case, we needed to pull 2 separate building permits. Originally, it was 1 code violation against the 2 combined spaces, but part of the resolution to the code violation was to separate the 2 spaces again with a demising wall to make them both separate tenantable spaces. That permit is permit number 211508, which is in process, and it was issued on February 25th, and will be starting inspections this week. The other side, which is Bay 2, was substantially more complicated for various reasons I won't bore everybody with, but we just got that permit finally issued as of yesterday at 2:21 p.m. So I now have permits for both sides of the both spaces, so we can now go forward, complete construction, and then go forward and get the BTRs with the new tenants, by the way, because this tenant isn't going to get a BTR. They're no longer in the space. So from a BTR standpoint, I would ask if the BTR part could kind of do a restart for the new tenants because they weren't part of the problem. They didn't create the issue. So I'm not sure how that part works.
Which there's no BTR, there's no portion of the BTR violation here.
And I'm confusing this one of the other 7 cases.
This is work without permits. Just a series
Yeah.
of different.
It's a work without permit. No, there's no BTR violation. He's probably
you.
thinking of his other cases.
That's my normal issue, sir.
That's okay, that's okay. So, based on the testimony I've heard, the order in this particular case will provide that there's to be 30 days to comply.
I
If
would
not,
request, if possible, to have 60. The problem is I just got the building permit, and we're having trouble getting materials and everything else, and construction out there is not going nearly as rapidly as it could, and 60 days, I believe I could be in compliance. 30 days, I'm pretty sure I'll be back over here paying a fine.
oh, the thing is that there are, this is, it's good that you've been forthright and you've been candid. It's bad not for you, but for the company you're affiliated with, that there's so many cases today, because
Understood.
it makes me think that they're sort of asleep.
Can I address that?
Not really.
Okay.
Because,
Thank you, sir.
it's just an observation. So,
I won't argue the fact, but we do have like 190 different tenant spaces, and unfortunately, these slipped under the radar on me. So this
Right,
is,
but you have to.
but I've got better radar now, and I've got a system.
This
You won't see
one,
me here again for
this
7
one is
cases.
extensive,
Yes.
and even though they had a year to comply,
Right, that's right.
I'm okay with the 60 days.
All right, because, I would, if this was just for what it's worth, it's based on what the town has said, because of the duration of it, I would not have gone with the 60 days, but I will in light of the fact that the town is agreeable to it. You'll have 60 days to comply. If not, there will be a $100 per diem until compliance is reached or effectuated. That's what the order provides, plus a standard $100 admin fee. So all permits for all work done without permits have to be fully in place within that time.
Yes, sir.
All right. What's the next case?
Next case is 5501, and that's on page 2. No, I'm sorry. Yeah, page 2.
5501?
Yeah,
Okay.
item 7.10. Okay. Chief Code Officer Jocelyn Ramirez, case 5501, property owner Hala LLC, tenant Terp Nation LLC. Prior to that, they had a tenant one-day bundle. According to the property manager, they're no longer there, which was also multi-skills, no longer there. So the current tenant is Terp Nation LLC. Site address, 3125 John P. Kersey Drive, Pembroke Park, Florida, Bay 7. A notice of violation was sent out by regular mail January 22nd, 21. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail March 3rd, 22, and posted to the property on March 4th, 22. Violations were for operating without a business tax receipt, installation of racks without permit. At this current time, there is no business tax receipt for Bay 7 and no permit obtained. Again, the property manager has been in contact, and he's currently working on getting that rack permit, and currently working on the tenant obtaining their business tax receipt. But they cannot obtain that business tax receipt until that permit is issued and completed. Therefore, I'm going to recommend.
They can't get a BTR as long as there's open violations, what you're saying?
Correct.
Right, that's okay.
I'm going to recommend 60 days, if not $100 per diem with a $100 admin fee.
reiterate what I've asked you in the other cases.
Rick Chapels, construction manager for the Kersey Group Management Company for this building. And I have a question. I don't necessarily, thank you for the 60 days, but I have a question. This particular case was opened up and issued in January of 2021 against the former tenant, Multi-Skills LLC, that was named at the time, I guess, One Day Bundle is what they put on their operational certificate. So is it possible to close this case, since it's against the BTR, which is required in this one, and the racks are both gone because the tenant took them all, which they were supposed to. We didn't want them. So this was all against the previous tenant, and I didn't talk about this with you, Officer Ramirez, prior, because I just kind of thought about this while I was listening to some of the other people speak. But it would be helpful if we could close this case and open a new one for the issues found during the BTR inspections, because once this new tenant, Terp Nation, found out they had this issue, because they never got noticed. They had no notice, and this goes to my land lease folks, so I don't get a notice as directly as I do if it's one of the buildings we own completely, and I don't have a land lease on. So, again, nobody's fault but my own. However, certainly Terp Nation wasn't trying to be out of order with anything and being out of compliance, and their racks, which they have, are 8 foot and lower. In the old days, 8 foot and lower didn't mean it was a rack system that you had to get a permit for. It meant it was shelving, which is they hand load and unload it by hand. So they never thought about a rack permit because they don't use a forklift to load and unload pallets.
But do they need a rack permit now?
Yes,
We had a
they always
conversation.
had, they always needed a permit.
Well,
So my answer to you is I've listened.
okay.
But unless, special counsel for the city tells me something differently, just under black letter code enforcement laws, I understand that despite your real estate leasehold arrangements, the violations really are essentially against the owner.
Yes,
And,
Yes.
they're attributable to the owner. And the tenant who is pulling the BTRs or the certificates of use or what have you is sort of maybe jointly or secondarily responsible, but ultimately it's the owner.
Correct.
And because of that truism, I see no
Okay.
legal duty or obligation to reclose the case or to reopen it. It seems to me, listening to all these cases, you need a better system of being advised of things on the property.
And we have one now, sir.
I hope so.
The thing that went, I'm sorry to interrupt.
No, that's it.
The other thing with it, in 60 days, I'm saying thank you to, first and foremost. So I'm not arguing that, but we do there's multiple layers to these things. You have a code enforcement violation, which dictates you need a BTR inspection. BTR inspection is another system that I don't have visibility into unless I ask for the individual who does the BTRs, which is, she's awesome. But we don't always get very good notice to help the tenants wake up to figure out that they have a real problem. And the real problem woke me up when I got the notice I had 7 cases in front of you this morning. So we're not going to do that twice.
I hope not.
But
because
the
the second time won't be as
I don't enjoy this any more than anybody else in this room enjoys it. So
the second time you may
all right, but
face
thank
an
you.
enhanced scenario. So
I'd
if you're back
prefer
here
not to
again
have
with that
that.
many cases,
Well,
because you might be a repeat, just things you don't want to do. So the order is going to provide for 60 days compliance. If not, there will be the $100 per diem and the standard $100 admin fee for every case. That's how we're going to dispose of this order. Do you have any more cases?
uno más.
Okay. Uno más, okay. Which one?
that's gonna be on page 3, and that's item 7.16.
6565.
Yes, case 6565. Chief Code Officer Jocelyn Ramirez, case 6565. Property owner Hala LLC. Tenant Always Towing and Storage Inc. Site address 2550 South Park Road, Pembroke Park, Florida. A notice violation was sent out by regular mail on December 10, 21. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on March 3rd, 22, and posted to the property on March 4, 22. Violations were for exterior walls of buildings, require maintenance, pressure wash, repair, paint, etc. This has been completed as of last week. The property manager did show me photos on Thursday of this week.
And you saw, okay. You saw the photos,
Yes, I saw the photo. They've been entered into the record as well. They have it.
and you're satisfied that there's compliance with those aspects?
Yes, with the exterior walls.
I need to know, right.
Exterior maintenance of parking lot requires maintenance, and repaving and striping. A permit needs to be obtained for that.
It was obtained yesterday at 2:33 p.m. So we do have an asphalt permit, repair permit.
And they're currently have a permit for it. The property tenants are double compact parking in front of the property, and that is prohibited.
I see that in the photos. Was that cited?
Yes. Prohibited parking on the road, they're parking on the road on the side of the building.
And that is prohibited, and was that, again, my question is, was that cited?
Yes, everything I'm mentioning has been cited.
See it by the photos where there's cars parked in the road, and there's cars that are, what did you call it, dual parked or double
Yes,
parked or
double.
whatever you call it? Right, double, right.
Okay. And then I stated, all towed vehicles must be parked within their parking lot, within the certificate of use limits. So they have to park basically the cars that they're towing into their lot. It cannot be in the appearance in front of the property or on the side of the road. They cannot use those areas. That's not meant for their business.
Chronic, if a towing company that had towed cars for improper parking violations was itself
I
in
actually have,
violation.
I have a different towing company that manages our properties for that very reason, sir, in case we have to tow from the towing company.
And then there was installation of electrical cameras without a building permit.
Those violations still exist.
Yes.
So what is your recommendation?
My recommendation is to give them 30 days, if not $150 per diem with a $100 admin fee.
And is there anything else you want to add at this moment?
No.
Okay. Sir, again, repeat
Yes,
the
sir.
same questions, and please respond.
Rick Chaples, construction manager with Kersey Group, property management for this building. And in this case, 30 days should be sufficient to at least start the process. The challenge is the permits that are going to be required to deal with the chain link fence. We did repair the chain link fence after a hurricane damage back in 2011. That chain link fence and the wooden barrier have been there probably since '91 when we started renting the facility. The other thing is I have pictures that were sent to me yesterday afternoon by the tenant showing, which has not been submitted to anybody, I can show them to you, but showing that everything at that moment, at least, was clear, and they didn't have anything on JP Kersey Drive, they didn't have any double parking out in front of their space. So they can be compliant because they were.
Right, but you have to understand that those photos, which if you want to show to the code enforcement officer or counsel, can be admitted into the record. I have no objection to them myself, but that's a snapshot in time at one particular moment.
Right.
If the other photos and evidence, just so you understand, show violations, I do find that they're violations because the photos clearly depict those vehicles on the street.
Absolutely.
And double parked.
Right.
So the fact that you have a photo of not a violation at a particular time doesn't negate the fact that there's photographic evidence of violations of other times. Now, if they didn't have these photos and you had just those, you might get the case dismissed, but that is not the case.
No, and
Okay,
that
so-
wasn't the intent. It was just to show that we have spoken with the tenant, and the tenant is aware that the town considers them to be outside their certificate of use if they don't put their towed vehicles in their yard, and if they continue to stage vehicles out on the public road. So the tenant has made it very clear to to myself that they will comply. They were, at least in a moment in time yesterday afternoon, in compliance with what was required. The other two things that have not been resolved in this code violation is items 6 and 7, which is the chain link fence, which has been pre-existing to us even taking this building. And, but we will work with, I met offline with the building official, and we'll get a permit to demo the wood that he doesn't like there, and we'll certify that the fence is done correctly. And the last thing is the electrical cameras, and those, the tenant is trying to get a building permit from a low voltage contractor. If not, we were advised that if they do wireless cameras, then they don't need a permit. So that was something that
Right.
came up.
I'd just like to state for the record, because I forgot to mention item 6, that there was an installation of chain link fence and wooden fence without a permit. So I'm glad you clarified that one.
Right, and again,
Glad
it
to
doesn't
self-identify.
But even so,
submit those into the record.
I'm
Show them-
happy that you have photos, but I physically have to inspect the property and make sure that those
Right, right.
vehicles aren't there.
Right.
Right now is not a time, to call an inspection. So
No, and
I-
we're not, I'm not
but
suggesting that.
I did see the photos.
No,
I
no,
did see the
mean-
photos.
Did see the photos.
The ones that he just showed in there
Yes, you have seen them.
just now.
All right. Well, so again, I'm just going by procedures. If he wants to introduce them into the record, do you?
Yes, I would
All
love
right,
to.
then,
Okay.
all right.
So if those photos hold, they take care of items 3, 4, and 5.
But did you hear my explanation?
I absolutely
All
understand,
right.
sir.
I find a violation
100%.
of those because the parking violations are depicted here.
No
The
doubt.
fact, I accepted the photos because you tendered them and there's no reason to object them. But it does not negate the fact that there's evidence of the violations, well documented
Yes, sir.
in the case file, which I have accepted into evidence as well, without objection. They're part of the record. So, and the fact, again, not to give you, counsel, because that's certainly not my role, but just to point general information, the fact that the wooden fence, the chain link fence, predate the ownership of the firm you're affiliated with is legally irrelevant. They own the property now, they're responsible.
Understand, sir.
Doesn't matter if it went in there in 1950, So the order will provide that there will be 30 days for compliance. I do find that there is violations as to the fence, as to the cameras and the permits required, and as to the parking and the other matters detailed by the officer. There will need to be compliance within 30 days. If not, there will be a per diem of $150 per day and the $100 admin fee. Standard in all cases is provided for as well. That's what the order states. I thank you for coming here, and I certainly hope that this owner or management company does not have as many cases in any upcoming hearing.
As do I, sir.
And thank you for coming in, and if there's no other cases, now would be the time for him to get copies of all the orders.
Mr. Magistrate, if I may,
Yes.
I'd like to just recall the very first case, 8.3, that's 6135, the DPT Group LLC.
Want to recall that case?
I do.
Okay, that's fine, but may I know why?
Oh, absolutely. That's exactly why. The owner of this particular property is Bainfair Inc., care of the Kersey Group, but the notices in this case list the property owner, and direct notice was DPT Group, which is the tenant. The same tenant that we have an order against right now as the property owner, which they're not, which apparently is going to be gone as of tomorrow. So because the notices themselves, although the property owner is aware and we appreciate it, the actual notice of violation lists the tenant, not Bainfair Inc. So, and the order, I believe, is also going to say DPT Group again, who's not the owner of the property. So in this particular case, I would recommend that we vacate that order, understanding that you had 120 days on this particular case. Everything is going to be exactly the same, because we're going to be back here in 30 days, if not 60 days, with the same recommendation, but that would give the town the opportunity to renotice the case under Bainfair Inc., which will be coming. The other option is if you want to go ahead and accept responsibility today and say that we're going to take over the case as the owner. Otherwise, we'll be back here in 30 to 60 days.
We'll take over the case as the owner.
Okay, so with that, with the agreement of.
And just for the record, and I appreciate you bringing that up, Counselor, because I always do look at the owner who's listed and whatever, but that one.
Correct.
So thank you for bringing that up. I need you to state on the record just what, that on that first case, 813?
6135, I believe, sir.
6135, okay.
Simply stated, the notice of violation was issued directly to the tenant.
And again, because I haven't, what you are proposing, counsel, is,
Either we can reset this case, or what they're agreeing to is take the order, which, in other words, we'll amend the order and amend the case. They're gonna waive any objections to notice, and the order will have to do an amended order, which you might have to get in the mail, which would then change the name of the case from DPT Group LLC to Bainfair Inc., care of Kelsey Charles and Lesser, or Charles M. Lesser.
and
They're
that
saying
would,
as the owner, they got notice of the case, they knew about it, they're on top of it. But essentially, the town sent notice, official notice directly to the tenant. If I may, can I have the case file? And I'll show you exactly what I'm referring to. And I'm showing the case file and the notice. If you want to see, you're more than welcome.
yeah, I would.
I've got a copy.
Yeah. Right, this came up in another case, but I guess it didn't, I did not find this, right, okay.
Right, with the actual notice of violation. I don't want to mess up the papers.
No. This one. Okay,
That's when I want to
So-
bring to your attention.
and that's case number 6135.
Correct.
So, but anyway, we just concluded this matter, this case.
Yeah, this is one, that's why I'm recalling the first one, because I was doing the research, trying to verify that.
Don't mention it.
Okay, so, look,
If I may, Mr. Magistrate, if,
Yeah.
The representative here, forgive me, for the name,
Rick Chapels.
Mr. Chapels is accepting responsibility on behalf of the owner, then simply what we can do is provide you an order which lists the proper respondent, and then in that order, we can add a line basically saying that they accepted responsibility for the case and the order and the time to comply, and they were aware. So we can go ahead and prepare that order and send that to you. We wouldn't have that ready today.
okay, the order heretofore entered on 6135, one of the earlier cases first heard, is hereby vacated, nunc pro tunc, and a new order will be issued based on the representation of, which I'm going to ask you to reiterate your name, that you're authorized to be here, and that you accept responsibility for that case.
Rick Chapels, Kelsey Group's construction manager, also agent to the owner, and I accept the responsibility as we discussed previously on 6135.
So, not even an amended order, just a new order will be issued.
Correct.
Listing, Banfar, Inc., Kelsey Charles Lesser, owner, as opposed to DBT Group LLC. That can either be prepared now, or Officer Ramirez, it can be either prepared now and rendered sometime today, or it can be prepared later and emailed to me, and it will be sent back to you, or whatever.
At the end of the meeting, we'll correct it, the order,
Okay.
and
So-
then we'll send it out by certified mail.
All right, so then you may leave, unless you want to wait till the end of the meeting, you may leave, and the town will send that to you. Fine, thank you for bringing that up. Sorry.
Thank you very much. Thank you for everyone's time and help.
Eric just said that he's gonna go ahead and fix it. So
Yes.
if you give him 5 minutes, he go ahead and fix it. He's gonna sign it, and we're gonna
Done.
go.
I will wait 5 minutes with no problem. Thank you.
So, that's one.
And I know that can happen with BTRs and CUs, but,
For 6135.
you know, just for what it's worth, the tenant should be at, if they're gonna be there at all, they should be secondarily or at a lower,
And I completely agree. Chapter 162.
right, that's required, so
He's getting there.
that's fine.
Okay.
¿No tiene una lata de basura aquí? All right, so it's not a big deal. It's not a big, okay.
You need one?
I just thought you had one here, but if you don't, that's fine. Don't worry about it.
I'm ready when you are.
Yes, I'm ready.
The next case is 5376.
5376?
Yeah, let me find it for you.
It's all, I just, you know, when I ask you for that number, it's so I can see
Yeah,
what the case
it's
number
page
is.
2, 7.6.
I realize that if I do Control F, I can
Yes.
get to the same case file. So it's not a federal case, but go ahead, yes, I have it.
You know, now that I think of it, maybe we should wait till the attorney comes back. Just in case, do you want to wait for the attorney?
Yes, that's fine.
Okay.
Anderson not here? Is Anderson, I'm just curious, Anderson is not
No,
here?
she's out of town,
Okay. it's-
so he's covering for her.
Yeah, no, it's just, Get to the bathroom now a little bit more directly.
We'll take a small recess.
Yes.
Okay, we're gonna hear case 5376 on page 2, item 7.6.
Noted.
Chief Code Officer Jocelyn Ramirez, case 5376, property owner Pembroke Park Warehouse Holding, Tenant Zeppelin Products, Inc. At this current time, I did get a phone call yesterday, and I was told that they're no longer there, that Zeppelin Products, Inc. is no longer there. So I just want to state that for the record. The site address is 3150 Pembroke Road, Pembroke Park, Florida. The subject real property is 3172 Pembroke Road, 3174 Pembroke Road, 3176 Pembroke Road, and 3178 Pembroke Road. The notice of violation was given by hand on October 7, 20, sent out by regular mail on October 8, 20. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail March 3rd, 22, and posted to the property on March 4, 22. The violations were for an unpermitted tenant build-out, unpermitted electrical and AC units, unpermitted structures such as mezzanines, stairs, and railings, and 3172, 3174, and 3176, and 3178 Pembroke Road warehouse units have been combined, so they demolished the fire-rated walls and combined the units without a permit. At this current time, as of March 3rd, 22, there has been no permits obtained and no re-inspections called in. My recommendation is, since this has been going for more than a year, is to give them 30 days to comply, if not a per diem of $250 and $100 admin fee.
This goes back to 2020,
Yes,
and you've had the same owner since all that time.
yes,
Is there anything else you want to add at this time?
no.
Sir, you are name, business address, relationship to the property, and then tell us what you want to say.
Yes, sir. So my name's Alan Granovsky. I'm just an officer for the previous tenant because we were named on this violation. So what I'm asking for, I spoke with Officer Ramirez yesterday because we had moved 3 months ago and relocated our business, so we only received the notification yesterday because it went to the old address by certified mail, then the post office has forwarded to us. So two things is, one is we're no longer there and we're a tenant. We were a tenant, excuse me. So I'm asking that if you can please remove us from this case, respectfully asking. And if you can't, then I'm asking to please reschedule it so we can obtain an attorney to have, we can find an attorney who can review this and come, represent us.
I'm going to ask if town special counsel has anything to say to that. I mean, I know I have an opinion already, but, I think that, again, the primary, as you've heard, the primary responsible party is the owner. If anything, tenants are maybe secondarily at best included, but code enforcement violations go against the property and against the owner. So the fact that you're no longer there is, frankly, respectfully, legally irrelevant to the fact that if you were there when the violations occurred per the testimony, that's what matters. It's like saying, for lack of a better, I'm not liable for the unpermitted house in Pembroke Park because after we built it, we moved to Fort Lauderdale. That doesn't matter.
I understand, sir.
So,
Sir, if you don't mind, I do want to just mention too that, we were first inspected by the fire marshal, and there was a list of about 15 minor violations, things like low voltage wires exposed, not having a propane placard or having pallets indoors, et cetera, all things that we could control. We took care of every single one of those violations. Everything that remained was structural thing, and that's why we had to move. Because it was structural, we couldn't take care of it, and the landlord wasn't taking care of it. We had to move after many years. And I provided Officer Ramirez yesterday with our new certificate of occupancy and business tax receipt showing our new location, respectfully.
Which that was the case that I decided to postpone earlier today. That was case 5377, which I postponed because he did, in fact, show the certificate of use of the other property, but there still hasn't been no reinspection called in for that property that will show me that the area is vacant and that there's no business there. So I told him, since I did not get sufficient time, I just got a phone call yesterday, I didn't get sufficient time to do that reinspection, I can't make a decision based just on the paperwork that was submitted. But we postponed that case, so we're not hearing that today.
We're not hearing that.
Yeah.
So on this case, if the violations occurred as shown by your testimony and in the evidence and in the photographs on file, which I see of electrical apparatus installed, seems to be shelving installed, electrical conduits and things installed, all without permits. If that did occur, this violation may go forward. Now, if the town wishes to remove Zeppelin, is that misspelled? Because Zeppelin is, anyway, but products from the case, that's up to the town because the owner is primarily responsible. But I have no problem with leaving them on because the testimony established that those violations occurred at a time when they were.
Right, and I have no way of determining who did what, who installed these racks. It could have been the tenant. And if they removed them, they didn't get a permit to remove them. So, because if you're removing something, you have to get a demolition permit.
Right. And then this hearing, based on what it said, was this hearing noticed as required by Chapter 162 and by the town code?
Yes.
So, I respect what you're saying, but the hearing was appropriately noticed. The matter does go back to
October 2020.
October 2020, sometime in 2020, I didn't know when. So, well over a year and 5 months, what have you. So, I think the matter can be heard today. Do you have any defense you wish to tender?
Well, if you're going to keep us on this case, then I do need to get an attorney. And there was no way to provide a 5-day written notice, which is what is required by an attorney, because we only received the notice yesterday, and I have proof that I have the certified letter that was postmarked by the post office saying it was forwarded to us.
But again, what they're required to do, and again, to get into this, is what they're required to do is, again, unless the town wants to agree to a continuance to reset this, what they're required to do is to notice by mail and or by posting and we can go through the notice in this case, and if they did that, it doesn't matter that you got it yesterday or whatever. That's not their problem. The issue here is that they post as legally required, that they notice as legally required.
Yes.
Magistrate, if I may.
Yes.
Just to respond to your earlier questions, again, here, Pembroke Park Warehouse Holding is the owner of the property. They were noticed, and the order is legally operative against them. As far as what is provided to the former tenant, again, the tenant at that particular time, as far as whether they're included on the case or not included in the case, is actually, it's not legally significant because, again, the owner and any liens are against the particular property. Now, as far as right now, you're testifying that you are no longer at the property, but as Ms. Ramirez testified that there hasn't been an inspection regarding the no LBTR. Additionally, there might even be some, depending on your new location, and also depending on your previous operation without a local business tax receipt, there might be additional fees, maybe not, maybe there's nothing else there. So as far as whether or not you're included on the case or not is actually legally irrelevant one way or the other, because the owner's responsible. So as far as moving forward today, I don't see an issue with that on behalf of the town. But as far as calling in that reinspection to say, hey, you're out of the property, you can do that, because again, I believe there's going to be some time to comply here. And then at that point, you would have your reinspection as to whether or not you're there, and that part of the violation will be complied. Any other issues as far as who did what and the responsibility would be a civil issue between the tenant and the landlord.
Now, you may or may not want to do this, but again, I only received notice yesterday. I have video after we moved out of showing everything empty completely.
Again, you can call the reinspection from Ms. Ramirez in her office. Now, as far as notice, Mr. Magistrate is correct, and there's case law to this effect where the town only needs to mail notice pursuant to the statute, not actually show receipt. And in this particular case, looking at the record, it was actually mailed to the property owner. Although you're listed in the case caption, it was mailed to the property owner at the 3172 Pembroke Road, which is also what's listed on BCPA. Therefore, notice was properly sent to the owner in this case.
Well, let me ask you this, would there be any harm, injury, or consequence if the tenant was removed? Because at least to me, the certified liens against the property, if it comes to that, any other action is against the owner. Or am I missing something here?
No.
Okay, so rather than just deal with what I consider a red herring, I am going to remove Zeppelin Whole products from the case, which only appears in the caption. It's of no legal consequence.
Okay.
You're not here representing the owner. We're going to just proceed with the case. You have to be mute as to the owner, because you have no authority to speak for them. I've removed you from the case, so you're welcome to stay and sit down, or you're welcome to leave as you wish, but you really have no further standing to say anything in the case. Thank you.
I understood. Thank you
All right.
very much.
You have nothing, what?
That's one question. I'm just curious, will I get anything in writing saying that we're removed from the case?
I'm removing you from the case now. If you just give me an amended order removing their name, I will enter the order as recommended.
Right. You don't have to stay for the order. Since the magistrate decided to remove your name, they will be sent out to certified mail to the property owner.
Thank you very much. Thank you, Mr. Ramirez.
You're welcome.
Okay.
For the record, Mr. Magistrate, the town does have a certified mail return receipt to Pembroke Park Warehouses at 3850 Hollywood Boulevard, Suite 400, which is the address that's listed as the mailing address on BCPA. So that was one of the additional addresses that the notice was actually sent to. As I go through the whole case, just making sure that notice was actually sent to that address.
Right, rather than, I just, nip it in the bud, rather than get into a whole debate here with this man about, it's really of no legal consequence, that's what I thought, so just,
Right, we agree.
Looking at the Broward County Property Appraiser records, it's Pembroke Park Warehouses Holding.
Yes.
That is the owner. So either I can just, by hand, which is not really the best, strike this, or you can just create
I'll create one by the end of the meeting.
and get it to me and,
Yeah, by the end of the meeting, I'll reprint it,
okay.
and then you can sign them.
Very simple.
Or do you prefer signing it now? What would you prefer?
I don't mind signing it at the end of the meeting.
Okay.
All right.
All right.
And as we stated before, just to be clear, because the actual notice of violation actually has a different address. I want to be clear on the record that the city, that the town did send it to the 3850 Hollywood Boulevard, Suite 400.
And that is the mailing address of record shown by the Broward County Property Appraiser, a printout which is part of the record, all admitted into evidence as with all the exhibits without objection, which is dated March 3rd, 2022. I take, administrative notice of that, and I think it was properly noticed to the owner,
Thank you.
which is really all you need.
Thank you.
And the other thing is a red herring in this case.
It is.
Okay? So we're not going to consume our time with that. Here is the amended order for the band fair. I am entering now, just as a matter of administrative cleanup, a amended order for case number 6135 for the matter of the town versus Band Fair, Inc., Kelsey Charles M. Lesser. This order, what did it say as to the fine originally? Because I don't. Okay, an amended order has been entered on case number 6135. With the corrected statement that Rick Chaples, president of the hearing, agreed to amend the code enforcement case to change the respondent from DPT Group LLC to Banfair Inc. Rick Chaples, as agent of the owner, waived any objection of notices to Banfair, was aware of the violations and has taken steps to remedy the violations, including evicting current tenant, DPT Group LLC. Okay, the order now entered, replacing the earlier order so provides, and you may give those to this gentleman who was waiting, and
Okay, next case is 5372. That's on page 1. Item 7.3.
thank you. 7.3, you said? I mean, item.
On page 1, 7.3.
Right. Okay,
All right. Chief Code Officer Jocelyn Ramirez, case 5372. Property owner Sarah Oquendo. Site address 3930 Southwest 52nd Avenue, Pembroke Park, Florida, Unit D4. A notice of violation was sent out by regular mail on October 5th, 2020. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on March 3rd, 22, and posted to the property on March 4th, 22. The violations were for an installation of metal fence without a permit, installation of awning without a permit. No permits have been obtained as of March 2nd, 2022. Therefore, I'm recommending that this gets complied with in 30 days, if not $50 per diem and $100 admin fee.
is there anything else you want to say at this time, officer?
Not at this time.
Miss, good morning. Please give your name, your business address, your relationship to the property, and state what you wish to say.
I'm Sarah Oquendo. I'm the owner of the property. I reside in the property. The address is 3930 Southwest 52nd Avenue, Unit 4, Pembroke Park, Florida, 33023. The awning, I know it was installed, I started like long time ago, but back then I didn't know I need to have a permit.
You do.
Now I know I'm working on it. I already had the drawings for the engineering. It's a lot of requirements, paperwork that I'm working on it. It's not like I forget about it. I already hired the engineering, he do the work, I had the drawings. I had the fire rating. So I know Ms. Ramirez gave me 30 days, but I asked him for 60 days to finish all the paperwork and complying.
And what about the other
fence.
matter that you mentioned with the fence?
The fence is two sides of the fence. I had to do it because it was a long time ago also because of security purposes. But back then, I don't know, 10, 12 years ago, we have a lot of criminality activity on the area. I was new in the area, so I installed the fence as a security purposes. And I didn't know I need a permit. Now I know. For the fence, I'm almost ready. I had the description of the fence and I have the drawing. So I just need to go to the building department. I filed the permits here right now, but the guy told me it has to be there and notarized there and all of that kind of.
You filed
issues.
down.
No, I'm ready for the fence.
Are
but
you going to go and file now?
Yeah, I'm going to do it not today, but by next week. And
You are? All right. Does she have any other violations or prior violations on this property?
No.
Okay. Has she had any other violations of any kind here?
Not that I know.
Okay. Are you a business there, or is that your residential use?
No, it's my home.
It's your home, okay. Under the circumstances, I'm going to give you 60 days to comply. No longer, if it is I sitting here, I will not give you any further time. You'll have the 60 days. You need to comply to get permits for both these items within 60 days. If not, there will be a $50 per day fine, daily fine, commencing on the 61st day until you comply. And there's a $100 administrative charge for every case that's heard.
Okay. I'm happy with the decision, and I tried my best effort to comply.
Please do so, because, what the town seeks is compliance, not, that's the primary objective. So if you comply, within the timely, and you get it approved within those 2 months, your loss for this should be limited to, $100, So, you understand?
Thank
All right, wait for the order.
Next case is on page 4,
Yes.
item 10.2.
Item 10.2.
Yes. Case 5142.
5142.
Yes. Chief Code Officer Jocelyn Ramirez, case 5142. Property owner Catherine S. and Daniel Fanfan. Site address 3911 Southwest 52nd Avenue, Pembroke Park, Florida. Building 5, Unit 3. This matter is here today for an abatement of fine. Notice of hearing to abate fine was sent out by certified mail on March 3rd, 22, and posted to the property on March 4, 2022. We're here to abate a fine of $1,000. It is the town's decision that we're going to abate this fine, the per diem fine, which is $900, to 10%. That would be $90. And the plus the administration fee, which is $100, it would be $190.
That's the town recommendation.
Yeah.
Anything else you wish to add at this time?
Nope.
Mr. and Mrs. Fan Fan, have you heard the testimony?
Yes.
For the record, your name and your address?
Katrina Fanfan, 3911 Southwest 52nd Avenue, Building 5, Unit 3, Pembroke Park, Florida 33023.
Okay, and again, for the record, I don't know if you've heard the other abatements. My position is on the abatements that if you agree with the town and there is a concurrence or a meeting of the minds, I will go along with that. If not, and you want the case heard, the abatement might be any percentage or it might not be any percentage, depending on what I rule. So do you agree with what the town is recommending or not?
Yes, I agree. Thank you so much.
Okay, the fine amount of $1,000 and so forth dollars is abated to a total of $190 per recommendation of the town and agreement of the respondent. This has to be paid within 30 days. If it's not paid within 30 days, remember that the original amount is reinstated or returns, comes back. Am I clear?
Yes.
So you have to pay that amount within that 30-day period.
Okay, where to go to pay in the front?
The town will respond that if you wait 1 minute here, you can get a copy of this order.
Okay. Thank you so much.
Page 3, agenda item number 8.5, case number 6728.
8.5? Yes.
This is case number 6728, property owner identified by Glenwood Court, Homeowner Association, President's Property Management, site address 3900 Southwest 52nd Ave, Pembroke Park, Florida, 33023. The violations are the parking lot is damaged and needs repair, and the entire parking lot needs to be restriped. A notice of violation was issued on 2/8/2022, sent out regular mail on 2/8/2022, notice of formal hearing on 3/2/2022, and certified mail on 3/1/2022. My recommendation is 60 days with a fine of $50 with a $100 admin fee.
Is there anything else, officer, you wish to say at this time?
What was that, sir?
Is there anything else you wish to add at this time?
No, sir.
Okay. Ma'am, give your name, your business address, your relationship to the property, and then what you want to tell us, please.
My name is Lisa Emanuel. I'm the owner of President's Property Management Group, and I do manage the association Glenwood Court. The violation, when you said what I need to say, just my take on what occurred, or?
Yes, any testimony you may want to give, not, yeah.
Okay, understood.
Not your opinion about the weather, anything like,
Understood.
Anything you want to say in response to this case, to this matter, yes, that's what I mean.
Well, I know it may be irrelevant. The violation date was 2/8, but it was sent to an incorrect address. What we have on the Division of Corporation Sunbiz is not where it was mailed, which was fine. I was able to still get it with February 15th.
This is a recurring issue. So here, per the property appraiser's address, because again, I go by that, not by Sunbiz, it gives mailing address, right, of looking at the case file of 4613 North University Drive, 565 Coral Springs, Florida. Yes. Was it sent there, officer?
Hold on just one moment.
Okay.
It was sent to that address, the 4613.
It was sent there. Well, that's where it's required to be sent. The fact that you have another address listed on Sunbiz, just so you know, code violations go to the property address on file with the property appraiser.
Okay.
The
We'll
town's not
update that.
required to go searching through Sunbiz to find out who is, you know.
That's
Okay.
fine. Thank you so
Well,
much.
just for the record, Florida state statute says that we may send it to the registered agent as Sunbiz.
I called
it's
and
a-
they told me that it would
Right,
be.
but it's not required.
It's not
right.
required.
What's
We
required
may,
is-
but
right.
it's not required.
Okay, moving forward, thank you. As far as the stop signs, they were corrected before the second notice came out, which was March 1st. And I did contact the building supervisor to make them aware of that.
What about the maintenance of the parking lot and the striping and so forth?
That we are doing proposals for, and this is an association with Board of Directors. So we have to kind of determine if it's going to be in a special assessment, and we did meet with the accountant on Monday of this week. And as soon as we have a meeting to determine which way we're going to do it, we'll start working on the process. We did receive 3 proposals, but the board has reviewed them, but they haven't responded.
Okay, well, I'm looking at the parking lot and some of it looks not particularly well-maintained, and I see at least one large crevice or pothole, which is not desirable. The town has recommended 60 days for you to be in compliance. Is that doable for you?
We have to
For
pull
the
a
respondent,
permit.
I mean.
Right, we have to pull the permit. It depends on how long it takes the city to provide us with that. We were allocating 90 days to see if we can get everything done, because we're not sure if it's going to be the full overlay or just to meet the requirements that they have. We prefer to invest the money properly than to spend 10 grand on just doing, to meet compliance, kind of do the whole parking lot. So that's where we are in the debate.
They have any other violations?
The only other violation they had was for the stop sign, but they did comply with that. I also spoke with Ms. Lisa. They're doing everything they can to correct the action. That's why I recommended 60, because they're showing good faith.
Okay, but they have to get up, you know, and by the same token, I understand that you might need an assessment for that or whatever, but that's internal. You should have a reserve fund for these things. Again, it's not for me to be counseling you, it's not my role, but, you know, the property owners, you know, or the homeowners association inability to act quickly is not attributable to the town. You know, they have to just, you know, you have to expedite things.
I'm listening.
Right.
I'm listening.
I think under the circumstances, you need a contractor to do this paving and maintenance, right?
Correct.
I'm going to give them 90 days.
Thank you.
That is the time, you know, I'd rather do that than to have you debating later with a magistrate whether, you know, this was enough or not. But as far as I'm concerned, if it's me, that's the full time. Again, delays of the owners or the association tax does not have anything to do with the town. So 90 days is all you would get from me. You'll have 90 days to comply. If you do not comply,
Mr. Magistrate, real quick, for the fine, I'm not sure if I had stated it, but fine of $100.
you'll have 90 days to comply. If not, there will be a per diem of $100 per day until there is compliance. That means, you know, all work that has to be approved. And, you know, there is imposed today the standard $100 administrative fee for the hearings. This will be the order entered here, and if you can remain a moment, you can get a copy of it.
Thank you.
All right?
Next case is on page 2,
Yes.
item 7.8. That's case 5387.
5387, thank you.
Yes. Chief Code Officer Jocelyn Ramirez, case 5387, Property owner, Pembroke Park Warehouses Holding. Tenant, Air Concepts AC Services, Inc. Site address, 3150 Pembroke Road, Pembroke Park. Subject real property, 3170 Pembroke Road. A notice of violation was handed on October 13, 20, sent out by regular mail October.
2020, you said? I'm sorry.
Yeah, 2020. Regular mail, October 14, 2020. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail, March 3rd, 22, and posted to the property March 4, 22. The violations were for interior renovations done without permit, unpermitted structure of mezzanines or second floor storage, electrical work done without permit. At this current time, the tenant has pulled an application. I did advise the tenant that that application that they submitted was to become null and void within 10 days as of March 3rd, 22. I haven't received any update to this permit, but apparently this permit under process number 94879 is pulled to correct all these violations. Therefore, my recommendation, since it has been ongoing for a long time, is to comply within 30 days, if not $100 per diem. I'm sorry, I wrote my recommendation here. I recommended 60 days, if not $100 per diem and $100 admin fee.
Do you have anything else you wish to add at this time?
Not at this time.
Give your name, your business address, relationship to the property, and then state what you want to say, please.
My name is John Franklin Southard. I'm a principal at Air Concepts AC Services. With me is Miss Claudia Pinzone. She's also a principal at the company. We do not represent the property owner, which is Pembroke Park Rental or whatever. We, as Ms. Ramirez said, we've tried to comply with the violations. We've done our due process. We've had plans prepared. We submitted the plans. There was an active application in for the permit. There was a request by the city plan reviewer to make some adjustments to the plans. We have been unable to get a hold of the engineer of record. We found out today his number has been disconnected. We don't know if he's still in business or if he passed away from COVID or what. But we're going in the process of engaging a new engineer, and we would request additional time to do so. If it's,
How much time are you requesting?
90 days.
I'm okay with the 90 days, given the circumstances.
Given the circumstances, I'll defer to the town's recommendation. If it is I want you to know that I would give you no additional time because while I'm aware of everything you're saying, these are general conditions suffered by everybody, and this goes back to 2020. So, we want compliance, but at least, my concept for what it's worth is, there needs to be finality to these cases. I don't believe in just, perpetuating them. So you will have 60 days to comply. If you're not
90 days or 60 days? We decided.
Sorry, I thought I said 60. If I didn't,
Well, I said I recommended 60 days. They requested 90s, and I agreed to the 90. If that's okay with you, Mr. Magistrate.
It actually is okay with me. So actually, the order provides, yes, 90 days to comply. You'll have 3 months to comply. If not, there will be a $100 per diem starting on the 91st day. And I would not be inclined, I'm mindful of your circumstances, but I would not be inclined to myself grant any further extensions due to the duration of this case. So I hope you can find the engineer or a substitute certified engineer. You'll have 90 days from today, and if not, the fine will be $100 per diem, and the $100 administrative fee applies. It applies to all cases. Okay?
Thank you, Magistrate.
That's what the order provides. If you want to remain a minute, you can get a copy of it.
Thank you.
Thank you.
Next case is on page 1, item 7.1. That's case 5366. Chief Code Officer Jocelyn Ramirez, case 5366, property owner Pembroke Park Warehouses Holding, tenant Mad Monkeys Events, Inc., site address 3150 Pembroke Road, Pembroke Park, subject real property 3152 Pembroke Park Road, Pembroke Park, Florida. A notice of violation was given by hand on October 1, 2020. It was sent out by regular mail on October 2, 2020. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail March 3rd, 22, and posted to the property on March 4, 22. The violations were for no business tax receipt, tenant build-out, unpermitted loft, unpermitted AC unit, and electrical work, all done without a building permit. The tenant has been in communication as the day of posting on March 4, 22. They mentioned that the loft, the AC, and the costume room were removed. I explained to the tenant.
Costume room?
Yeah, costume room. It was a room. So I'm sure they removed the walls. So all of this was done without a permit. I explained to the tenant if they're going to remove anything, they have to get a demo permit to cure the violation. But no permits have been obtained that I know of as of today. So I'm recommending that this all get done within 45 days, if not 150 per diem. Now, let me correct that. $250 per diem and $100 admin fee.
Is there anything else you want to say at this time?
Not at this time.
And the pictures in the file for all the exhibits which are accepted into evidence depict the various violations here of the unpermitted work that was done. And I guess since it is a party rental, magic, special events place, that the costume room is actually what you meant, a costuming room. Okay. I see the electrical work as well. Sir, your relationship to the property, your business address, and what you want to tell us, please.
Yeah, good day. My name is Vladimir Shvets. I'm the owner of the business. We are renting the unit at 3152 West Pembroke West Pembroke Road, Hallandale, Florida 33009. When we met the first time and I received all the issues that we need to fix, some of them, for example, the unit and the loft, it was already when we moved in. Yeah, it was already. So
and again here, I know Mad Monkey Events Inc. is a tenant, but the primary, there's been several tenants appearing here today for the owners, so you're included in this because you were occupying the property as to some of these violations, but the violations are really against the owner and the property. I don't know if I need to elaborate on that further, but I'm only mentioning it because it seems that we've had several tenants appearing here today with the impression that the case is somehow against.
Well, this one is against him too, because he's
Right.
occupying the property without a business license. And he can't obtain that business license until all these violations, all these permit violations are corrected.
And to that point, it doesn't matter who did the violation on the property. Whoever is on the property is sort of stuck. So, they're responsible. So it doesn't matter if a prior tenant did X, Y, Z. It wasn't caught in time, sadly. But if you're there now, and if you're leaving, it's maybe of no consequence. But if you're there now and you want to operate, it's becomes your duty. Do you understand?
Yes, of course.
Go ahead with what you're saying.
Yeah, I just want to say that all the issues that was already that we made and that we need to fix, so we did fix it. We're just waiting for someone to come to like to see that, like the same as you saw already. And I made the pictures. If you want, I can show you the pictures that we fix everything that we could as a tenant. But the last time, our last conversation with Ms. Jocelyn, she said that there is no permits at the office at all that we moved in. So when we moved into the warehouse, we moved into the office, and Ms. Jocelyn told me that the building, the Pembroke Business Park, has no permits for that particular office. And basically, this is something that me personally, I cannot do anything without it. But we work close with the management, and I'm pushing them to get all the permits to have everybody to get all these permits and all these issues done. If it's possible, I want to ask to make it for 60 days. If not, it's okay. I will just forward it to them that we do have 45 days to fix all the issues. Everything that I could make, I did it, and we also will work with the permits of like demolition permits and everything like that. I spoke already with the fire officer, so we put the exit signs, we connected them, we put the new extinguishers, everything that he told me to do, like we did it already. So.
But have you had re-inspections since you've done those things?
No, I called already. I asked to come, the inspector to come,
Yes.
so nobody came yet. So we're just waiting
Keep
for
calling,
inspector to come.
and please feel free to reach out to.
Well, if they're gonna obtain the permit, they gotta call in inspections to make sure that everything was removed. So a structural inspector will go ahead and verify that. If there was electrical inspector will come. So it's a process. They can't do it in themselves. They need to get a contractor to go ahead. They need an engineer to draw out plans. But it's their decision what they're gonna keep structure-wise, electrical-wise. It's up to them. If they're gonna demolish everything, then they get a permit, make sure everything is
Demolition
kept out
permit.
correctly.
Sometimes people are not, know, but sometimes people may not be certain about what actually is required. If you have any confusion about that, I don't know if you do or not. Sounds like you may actually, I doubt that you're not confused because you sound like you might be a little bit confused. You should go see the city officials now or make an appointment with her later so you don't have these issues going forward, because you do need contractors. It's not sort of a do-it-yourself thing. That do-it-yourself is only at your own home, and to a degree. Is there anything else you want to tell us?
No, thank you very much.
Okay, I think in light of all the circumstances, and they seem to be acting in good faith, I'd rather err a little bit on the side of reason. If it's some reasonable extension request, I think another 15 days is. I will give the owner and this respondent, Mad Monkey Events, 60 days to comply. But again, that means to me that I don't believe in needless hearings. I would not myself give any further extensions or time. So 60 days to comply. If not, there will be a daily fine of $250 a day until you've complied. That is, until you have the permits that you need. And a $100 administrative fee is imposed today for each case, including this case. So again, please work with the contractors. Please schedule appointments with the town so you are certain of what you need to do. You have 60 days to comply, and that is it. That's what the order will provide.
Thank you
And
very much.
if you want to remain a moment, you can get a copy of the order. But again, I encourage you to meet with the town because I wouldn't be inclined to grant other extensions. Thank you.
Thank you.
Next case is on page 4, item 10.1, case 4560.
Thank you. Hang on one second. You said 10.1?
Yes.
Speed, please.
Okay. Chief Code Officer Jocelyn Ramirez, case 4560, property owner AX Points. Site address 4900 West Hallandale Beach Boulevard, Pembroke Park, Florida. This matter is here today for an abatement of fine. A notice of hearing to abate fine was sent out by certified mail on March 3rd, 22, and posted to the property on March 4, 22. We're abating a fine of $28,558.50. And
Got it.
the 50 cents is because of the recording of lien. That was 58.50. That's where the 50 cents come from.
I see.
Okay.
Thank you.
We're reducing the per diem fine to 15%. That per diem fine is $32,600. And that would be $4,890 plus the administration fee, which is $100.
So we're talking about 4,900.
And I'm sorry, and plus the recording of fee, which is $58.50. So that's a total of $5,048.50.
So we're talking about a reduction of 32,600 to $5,048, basically. 5,040, is that what you just recommended? But correct me if I'm wrong. Sometimes these things are all stated quickly and I may have misheard something.
The total is $5,048.50.
Okay. Sir, you are a business address relationship to the property, and you've heard the spiel, as it were, as I've given in the other cases. I need to know if you accept the town recommendation or if you want a hearing.
All right. Jim Ludwig, Access Points. Our address is 1128 Powerline Road, Deerfield Beach, Florida. I guess I have to agree.
Well, you don't have to agree. It's just that, see, the way I view the law on mitigation is if there's a settlement and you concur and there's a meeting of the minds with the town, then I can enter the order because the parties have in effect agreed. But if you don't agree and you're actually saying you want to debate and have an exchange and evidence about the different factors in mitigation, the equities or the lack of the equities or the factors, then we have to have a full-blown hearing, and then it would not be an agreement, so it would be whatever order
I understand.
I enter, and you know.
So that's what we're stuck at then. So I guess I agree.
Can you hang on one second? I just want to make sure the math is correct because The town commission did cancel the daily fine from March 18, 20 to June 10, 20 at a per diem of $50. That was for 84 days, and that's a total of $4,200 that was reduced at the time of the pandemic.
So why don't you do 15% of the,
Yeah.
if you don't mind, the 32,600
I'm gonna
minus the
reduce
48.
that, yes.
Right,
So I want to make sure that that was reduced in the price that,
Take a moment and do that, and then we'll reiterate what your recommendation is.
Thank you.
And replace your early, just take your time. Code compliance officer, please, take your time.
okay. So after reducing the $4,200 of the per diem fine, which was $32,600, the total came out to, and that's including the admin fee and the recording of the lien.
Yes.
That's $4,418.50.
Going to repeat, the recommendation now from the town is $4,418.50 as opposed to the $5,000 whatever.
Yes.
Sir, I repeat, do you accept the recommendation of the $4,418.50?
I'll take it.
Okay? Fine is abated to $4,418.50. As always, with these orders, has to be paid within 30 days. The $4,418.50 must be paid within 30 days. Please remember that.
Will they send me an invoice or I just pay it?
No, you're going to receive the order, and the order is your invoice unless the town has some other practice that I am unaware of, frankly.
No, it's just the order.
And I would encourage you to remain and get a copy of the order now. And please remember, because I do recall seeing you, sir, from the case, that if you don't timely pay, the much larger original order will be reinstituted. And you want to avoid that, I would think.
I understand, yes. All
So,
that will be paid.
all right, get a copy of this now, please, if you would.
Thank you.
Thank you.
Have a good day.
Thank you for coming in. Hope your arm improves. Sorry.
Page 3, agenda item 8.6, case number 6729. I'm Code Officer Richwagen, representing the City of Lauderhill. Property owner is Pembroke Park Affordable Housing, LTD.
Wait, hang on one second, because just give me a moment, because sometimes I need to.
No problem, sir.
What case did you say it was?
I'm sorry, could you repeat that, sir?
Case 6729, case 6729. Okay,
Yes, sir.
Got it. I just,
And representing the
just give
town,
me a few
correct?
seconds to get the file. I'm not instantaneous. Thank you.
I'm Code Officer Richwagen, representing the town of Pembroke Park.
Yes. At Lauderhill.
It's a, yeah. Property owner Pembroke Park Affordable Housing, LTD, site address 3700 Southwest 52nd Ave, Pembroke Park, Florida 33023. I find them to be in violation of discoloration on the exterior building walls, discoloration on the parking curbs,
Okay,
discoloration on the sidewalks, discoloration on the stairwells, discoloration on the perimeter walls. There were several abandoned vehicles. However, I did speak with the property manager who was here. She was able to get them removed.
and officer, you have confirmed that through your own reinspection or?
Yes,
you know?
when I was there yesterday, I was riding the property. I actually met up with the property manager in her vehicle and confirmed that the abandoned vehicles had been removed.
Okay, go ahead.
The notice of violation was issued on 2/9/2022. It was delivered regular mail 2/9/2022. The notice of formal hearing was issued on posted property on 3/2/2022, certified mail on 3/1/2022. It is my recommendation, seeing as they are in the process of getting a contract to get everything pressure washed, I would recommend 60 days with a fine of $100 for the fines and a $100 admin fee.
Thank you. Officers, is there anything else you want to add at this time? There being nothing additional, ma'am, your name, your business address, your relationship to the property, and then tell us what you want to say.
Okay, good afternoon, sir. I'm representing Pembroke Park Affordable Housing, LTD. I'm the property manager. Address is 3700 Southwest 52nd Avenue, Pembroke Park, Florida, 33023. And yeah, we have received.
And but you neglected to give us your name. We need your.
Oh, sorry.
We need to know who you are.
Janiris Flores.
Janiris Flores. Okay. Okay, no, that's fine. Go ahead. Go ahead.
We have received a quote. The only thing is that they haven't given us a time frame yet, so we're looking for other proposals so we can get it done as soon as possible.
This doesn't seem to be particularly complicated to me, but again, I'm not a contractor. I'm not in the business. Is the 60 days seem adequate for you to take care of this?
Yes, I would think so. Yeah.
So, based on the testimony and all the evidence and the totality of it that I've heard, I'm going to enter an order finding a violation as shown by the testimony and all the exhibits which are accepted into evidence. I'm going to provide that the respondent has 60 days to comply, that is 2 months, and if they have not done the corrective work and you need a reinspection for that to show it, within that 2-month period, within the 60-day period, there's a $100 per day or per diem fine until there is compliance, and there is, of course, the standard $100 admin fee for all cases heard imposed today. That's what the order provides. Thank you for coming in. Please remain for a moment to get a copy of your order.
Thank you so much, sir.
Thank you.
Page 3, agenda item 8.1, case 5737.
5737.
Yes, sir. I'm Code Officer Richwagen, representing the town of Pembroke Park. The property owner is Affinity AZURE LLC. Site address 3252 Southwest 52nd Avenue, Pembroke Park, Florida 33023. This property is in violation of the following. There have been multiple air conditioning units that have been installed throughout the property without permits. There are units that have had water heaters installed without permits.
Okay.
There is roof damage resulting in leaking in several units. There is electrical work that has been done throughout this complex without a permit. The entire parking lot of this complex is in disrepair and requires maintenance. There are several broken and unpainted parking bumpers. The sidewalk inside this complex has several broken, cracked, and uneven sections. There are several exterior lights that are broken and/or inoperable. There are several broken mailboxes inside this complex. The entire property has excessive growth that requires cutting and removal. There is bulk trash throughout this property that needs to be removed. There are several abandoned vehicles on this property without license plates, tags, and/or have expired tags. There are several overgrown trees throughout this complex that present a health and safety concern due to them being hanging over the actual units. There are bare spots on the grass all throughout this complex. There are several exposed pipes throughout this complex. This is a health and safety concern. The sidewalk inside this complex is dirty and requires cleaning. Give me 1 second. Oh, sorry. And that concludes it for the violations. A notice of violation was issued on 1/24/2022. It was posted to the property on 1/24/2022. Notice of formal hearing was posted on 3/2/2022 and certified mail on 3/1/2022. I have been in contact with the property manager, I'm sorry, I'm going to butcher the name. Ramirez?
Yeah.
Okay, Ramirez. I had spoken to him because he contacted the city. We spoke over the phone. I explained all the violations to him. We had discussed me coming out and doing an assessment of the property to go through all the violations. We also corresponded through emails and through Lucy in the building department. The assessment was never scheduled, and after several phone calls and emails, I heard nothing back in this matter. My recommendation, due to the health and safety and the numerous amounts of violations, is no more than 30 days, and I recommend a fine of $250 per violation with a $100 admin fee. At this time, this concludes my testimony.
And I have a question on this matter.
Yes.
For either you or special counsel or whoever from the town here. It is customary, and I have seen in various code enforcement violation proceedings that there's a fine for each violation. But my question to that is, was this violation cited in that manner? Because to my knowledge, and again, in all candor, because I am not personally familiar with that practice in this particular.
Or if I may, Mr. Magistrate, looking at the notice of violation, we're happy to show you can actually see what it does. It breaks out each individual violation, and also has the time to comply for each of those as well. So each of those are being, and that's actually the standard as far as it looks like on all the different notice of violations. In this case, given the egregiousness of the violations, I think that's why the town is making that a request, also given the number of violations. As to, again, and as each individual violation complies, then the fine is going to stop for that individual violation. So, but here they are listed individually all the way through the notice.
In light of that explanation and the evidence of record, and the fact that they are listed individually, and I take administrative notice of all the foregoing as well as the exhibits that are in the code enforcement file and are identified here on screen, which are all accepted into evidence without objection. I will accept that as a satisfactory explanation that these were jointly and severally issued as violations, looking at the documents, and they will be considered as such. And again, I know that to be a prevalent practice in various places, but
And also, as a point of clarification, Mr. Magistrate, you can see actually the notice talks about a repeat violation. The town is not seeking a repeat violation in this case.
right. You know, the repeat violation would kick it conceivably to 500.
Correct. In this case, although there appears to be prior warnings, prior issues, there's not a prior order that I'm aware of after discussion with Mr. Richwagen.
Right. We would need a prior order.
Correct.
Finding the same violation with this
Within the past
respondent.
5 years, yes.
Right. So, that being said, yes, there's certainly, just as a matter of observation, more and multiple violations here than in any other case we have heard today. Sir, what is your name, your business address, your relationship to the property, and what do you want to say?
Yeah, so my name is Moy Maras. I'm the property manager of Infinity AZURE LLC. Our property address is 3252 Southwest 52nd Avenue, Pembroke Park, Florida 33023. So let's, if you want to start with the first one, with the AC units, he says that they didn't have installed without a permit, so we bought the property about a year ago. The owners were supposed to have the permits, take care of it and everything, and then recently I was told that they were all voided. To my knowledge, those were all fixed already. They weren't voided or not. I mean, that was the seller's responsibility. They were supposed to take care of it. And I have the list here. It's like 20-something ACs that were all, I just got the email, they were all voided, so to speak, and I have
They were voided for some, but if you've heard, and again, you may not be in the weeds on this code enforcement stuff, and that's fine, but if you've heard what has been said in the other cases here. Whenever it happened on the property, the owner, at the time of the citation, is responsible. So,
I heard
you could own a house and somebody did an illegal addition 10 years ago, it doesn't matter.
Yes,
so move on to some other argument.
Okay, but I'm saying, just point is that they're getting taken care of, all those violations.
But you haven't told me that they're being taken.
So, Mr. Magistrate, I just want to let you know, although this was scanned, if you wanted to physically look at it, I do have a copy of what was submitted for ACs that have been voided and or terminated. I didn't know if you wanted to physically see this copy.
And again, just for my edification, I can see it. I'm always interested, but voided, I'm not sure I comprehend or have followed. The violations have been voided or the permits were voided? I don't.
The permits.
Okay, so the permits have been voided. That's all I need to know.
Yeah.
I mean, for some reason, per the code, the permits were voided. So you understand that the permits aren't.
I know.
Okay, so,
Yeah, that happens when a permit, there's no response to it for a certain amount of time. I believe it's 60 days that the building department gives them.
Yes.
And if they don't
Right.
respond, they expire, they become null and void. They
right,
have
no
to.
response within.
So
right.
technically, they don't have no permits. They have to restart and submit the permit application again.
And that's what happened, the lack of response within the prescribed 60-day period for all these ACs.
Yeah.
Correct.
Okay, so, all right, so I think I understand that currently have no valid AC permit, so.
Right, so
we
all
have to-
those 20 permits are getting, right now, I mean, we're putting pressure on the company to redo the permits. I mean, obviously it's our responsibility, but the point is that we're pushing them and we've got our lawyers involved to take care of it so they can redo that as soon as possible. The second one is the water heaters. I would love to know which exactly water heaters he's referring to know which ones don't have permits. Again, we bought the property a year ago,
right,
so.
and you direct your
Attention to you?
statements to me, but I won't be responding to them. The officer will respond to that.
If you recall, I spoke with you on the phone, and we corresponded through emails in discussion of setting up an assessment for me to come out and to go over each violation and to go through each unit. You failed to give me a schedule. Seeing as we had to go inside the units, you had to advise the tenants. You didn't get back to me. I called you and I even emailed you. The last correspondence we had is when I posted the notice of hearing. I did everything that I could.
He's asking what unit the water heaters that you
Correct.
cited.
Correct.
For the unit for that one, that would be 5321.
Do I have a pen or can I write them down? Sorry. All right, 53.
5321.
Magistrate, if I may.
Yes.
If the respondent, through the magistrate, if you could let us know if you're contesting any of the violations, only for the fact that if there's information that you need regarding which ones, we can, again, as Mr. Richwagen said, he can set up that meeting or get that information from him. We don't necessarily have to do that here at the hearing.
Oh, so then that's going to be my question for almost everything. I mean, the things I
Okay.
Well, you have, I mean, I agree with counsel, but I'm always very mindful of due process that.
Always.
If you have questions about something that you've heard, you're entitled, you have the right to ask questions of the town, that's your right. I mean, this is a hearing, right? So think of it like a trial. You have a right, but you don't need to do it now. But if you want to ask any questions about anything you heard, you have a full right to do that now, and I don't want to,
I could do it after if it's easier. I mean, it's going to take time. I want to go, that's going to be my question for a lot of things besides the things I repaired already. Like me walking in the property, I could tell you, hey, this is, the landscaping wasn't done. The landscaper came for the last 2-3 weeks, and he's been on top of the landscaping, so the landscaping got taken care of. The cars, we got that taken care of. But like those things, I could see that.
But, okay, so if what you're saying is to sort of try to bring this to an efficient exchange, if what you're saying is you've complied with several things, you can ask the town what it takes for you to show your compliance. Because you see, once his testimony is here and the photographs show noncompliance, I am, based on the testimony, going to find noncompliance unless you have something to rebut that never happened. But if you're saying you've complied now, then you need to ask the town how you can make that known. Not me, the town.
You have to call Officer RICHWAGEN and call him for a reinspection.
I will call him today.
For each and every violation that you said is in compliance, just, I'll come out, show it to me, that way I can verify and take pictures.
Perfect. Okay.
That way, it helps you to not accrue a per diem fine. So every time you complied with one of the ordinance, the violations, that fine stops.
Yeah.
We're not going to give you the $250 for that one. So you want to be actively calling him every time you correct something.
Perfect. Yeah, will do.
What else do you want to say?
No, that was that for all the things that were taken care of, and the ones that like the ACs and ACs I know, but like the water heaters, the roofs, so like those things I would love to be. I left him to be specific with which ones.
Okay, and the town has recommended 30 days.
Yes, due to the health and safety, for some of them, I recommend no more than 30 days.
No, I am going to, I will diverge at times, but again, respectfully to you, and but witnessing and looking at the evidence and listening to the testimony, there is a whole slew or cornucopia of violations at this property address. Some serious, quite a few serious, and some less than serious, but due to the totality of all those facts, I do find that there's a violation as charged. You will have 30 days to correct. If not, the town has charged, and it is in the notice of violation, that one, I'm making a finding of fact that you have a multiplicity of just multiple various violations here, all existing on the property. And due to that, and due to the severity of some of them, the fine will be $250 per day, per violation, if in 30 days they're not complied with. If you comply with some of them, the town will not be, I believe the town acts equitably and justly, and if you comply with some of them and you demonstrate that in time to the assigned code enforcement officer, I don't believe that there will be, when it comes time to, for lack of a better word, collect this, I don't believe that they will be collecting for the violation you have corrected in time. But for each of these things that you heard that isn't fixed, I'll make it simple, in 30 days, there'll be a $250 a day fine. If they're fixed, you don't have to worry about it further.
I understand.
That's what the order so provides. The $100 administrative fee assessed for all cases is also imposed. So the order will find violations as charged. You have 30 days to comply. If not, there will be a $250 per day fine until there is compliance. Anything that you have complied with will in effect be mooted or, not apply to going after the 30 days. If you have any questions?
Nope, that's
Okay.
all.
That's the order. If you remain a moment, you can get a copy of it.
Perfect. Thank you.
And I would encourage you to be in touch with the code enforcement officer as soon as possible.
May I have my pen back, please?
All right, page number 3,
Yes.
item agenda 8.6.
8.6?
Yes, sir. Case number 6729. I am Code Officer RICHWAGEN, representing the town of Pembroke Park. This is
6729.
Yes, sir, 6729.
Okay, hang on a minute.
Oh, I apologize.
I didn't think it was-
6731.
Okay. I thought we had, right, okay.
It'll be It'll be agenda item 8.7.
Right,
correction.
I have it now.
Apologies for that.
What?
Apologies for that.
No, it's fine.
This is property owner Pembroke Gardens LTD, site
Yes.
address 3701 Southwest 48th Ave, Pembroke Park, Florida 33009. The current violations are overgrown trees on the property. Several stairs inside the complex are discolored and require cleaning. The sidewalk inside the community has discoloration. There is trash scattered throughout the complex that needs to be removed. There is discoloration on the exterior building walls. There are abandoned vehicles inside this complex that need to be removed. A notice of violation was issued on 2/9/2022, regular mail 2/9/2022. Notice of formal hearing posted on 3/2/2022 and certified mail on 3/1/2022. My recommendation is 60 days with a per diem fine of $100 with an admin fee of $100.
Would you repeat the recommendation again?
The recommendation of 60 days with a fine of $100 for the violations and an admin fee of $100.
Is there anything else you want to add at this time?
No, I have spoken with the property manager. 60 days is sufficient.
I would say maybe 90 for the pressure wash, because we do have to follow chain of command, and I just got a proposal, but I'm not sure.
Okay, wait, before you start talking, please give your name, your business address, your relationship to the property,
My name is
and then you can say what you want to say.
Okay.
In that order.
My name is Catalina Montano, and the property address is 3701 Southwest 52nd Avenue, Pembroke Park, Florida 33023, and I'm the property manager. And like I was just mentioning before, for the pressure wash, I would like to get 90 days because we do have to follow chain of command, and I recently just got the proposal for the pressure wash. But we have we're taking care of the trees and the garbage and also the cars. I believe in the past 2 weeks we have towed like maybe 10 to 13 cars that they were abandoned with expired tags. And
I'm sorry, quick question. Have you been sworn in?
I did.
Okay, just making sure. Thanks.
Yes, you were here in the morning, weren't you?
Yeah.
As the podium is blocking me, so I wasn't sure if she was sworn in.
No, it's fine. It's
Yeah.
a fair question. Go ahead.
And so, yeah, so we basically need maybe 90 days for the pressure wash. And like I just said before, we took care of the cars, and we have been walking the property once or twice a week, towing all the cars.
You have been?
Yeah.
And you're going to continue to do that?
Yeah, we usually do it like once or twice a week.
And you will follow that procedure because it seems to be a recurring issue there.
Yeah. Mm-hmm.
Is this their first violation there?
Yes, this is their first offense.
Okay. What do you mean by chain of command? I mean, that sounds like an armed services term. I don't understand what a chain of command. I mean, is it?
Well, I have a new supervisor, and I don't know who's taking her place. So, like I just said before, I just got the proposal for the pressure wash, and I have to give it to my new supervisor. So I don't know how long it's going to take. Everything else, I can do 60 days, but maybe for the pressure wash, I would need 90
Well, listen, I understand what you're saying. You said they have no other violations. As to the town, I want to ask, or I ask you as well. So, it's I don't want to necessarily bifurcate that, they have X days for this, X days for that. It's just unduly complicated in my opinion. I'm inclined to just give them the 90 days for the, and if you do it earlier, what I was explaining is she said she need 90 days for the pressure wash. They have no other violations. I'm inclined, unless the town has strong objection, to go with the 90 days. Because they don't have other violations. And again, it's just my general belief that I rather give a reasonable time and not have debates about that than ever be back here on further extensions, because I don't believe in further extensions.
Understood. I rode through yesterday, and I did see that they were in the process of removing a lot of the trash. I did notice a lot of the abandoned vehicles, the very noticeable ones, were gone, seeing as they are showing good faith and they are in the process. I can agree with your recommendation of 90 days.
Okay, and that's fine, thank you. And again, remember, and again, not to put too fine a point on it, but it's the town's recommendation. It's the magistrate's ruling. It's the other way around.
Yeah, so my recommendation would be to up it to 90 days.
Thank you, officer. All right, in light of all of that, we will give you 90 days to comply.
Thank you.
But, you know, there'll be no further extensions. You know, you have multiple violations. So the chain of command, whatever the new supervisor, that's internal. That has nothing to do with the town. So you better work everything out within that time and have permits. If you have not complied within 90 days, and it's also, the 90 days is also because you've had no other violations, there will be a per diem or per day fine of $100 per day until there is compliance, which will continue to accrue until there's full compliance. The $100 administrative fee that is imposed for every case is imposed as well. And if you can remain here a moment, you can get a copy of the order, if you would please.
Thank you.
And that will, unless there's anything else, that concludes this matter. All right, remain for a copy of the order, please.
Magistrate, can I just,
Yes.
point of clarification?
Yes.
You know, looking at as far as at least the 90 days, at least for the respondent, please note that it's 90 days to comply, not begin. Understanding it looks like a very large job and understanding that you're saying that your supervisor might need additional time to review. Please note that this 90 days also includes time to finish the job as well.
Yeah, point well taken. What, right. What council meant, right. The 90 days or the 60 days or whatever you heard, Ms. Rodriguez, would be meaningless if it was just to start. That's not the idea. That's, you have 3 months to comply, which means you have to have the work done, you have to have the re-inspection done, and it has to be all finished within that time. If not, you face the fine.
Yeah, I just asked for 90 days because I had the same issue with Pembroke Villas. And we did the pressure wash and everything took like about 60 days. So,
Yes. Well, that's fine. We gave you the 90 days.
Okay.
I gave you the 90 days, but what council said is correct. That means, I think you understand, but that means 90 days, it's concluded, it's
everything else.
completed. It's been re-inspected and approved. It doesn't mean that you're underway with the contractor on site. It means, it means what they call in construction, full completion. Is there any doubt about any of that, or?
No.
Or anything else here?
No, okay.
All right. Did you get a copy of the order?
Yeah.
Okay. Well, thank you for coming.
Thank you.
Page number 3. Oh, I'm sorry. I thought you were on. I apologize.
I want, in the cases going forward, I just want it noted for the record that there is no one else present in chambers except town staff, professional council staff. There are no other, law enforcement personnel. There are no other respondents here. So these cases can now be conducted in a more abbreviated fashion. Okay?
Yes, and we will go in the order of the agenda,
Yes,
starting
we'll
with
go in the
page
order of the
1.
agenda. Yeah.
Starting with page 1, item 7.2. Okay, Chief Code Officer Jocelyn Ramirez, case 5370, property owner Veronica and Warren Appleby, Stacy Appleby, and Duane Warren. Site address 3924 Southwest 52nd Avenue, Pembroke Park, Florida, Unit C4. A notice of violation was sent out by regular mail on October 5th, 2020. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail March 3rd, 22, and posted to the property March 4th, 2022. The violations were for an installation of wooden fence without a permit, installation of wooden gazebo without a permit, electrical work done without a permit, and at this time, no permit has been obtained. My recommendation is to give them 30 days to comply, if not, a $50 per diem and a $100 admin fee.
$50 per diem, you said?
Yes, it's residential. First offense.
Based on the testimony unrebutted and the evidence of record, all accepted into evidence without objection, the order entered in case 5370 shows violation as charged, 30 days for correction or cure, and if not, there will be a per diem of $50 per day, plus the $100 administrative fine. It's hereby imposed, or fee, I should say, rather. On all these cases remaining on the agenda going forward, staff will please retain a copy of the order, and it will be mailed as required by law because the respondents are not here to accept.
Chief Code Officer, I'm sorry, we're still on page 1, item 7.4.
You don't need to make a copy. No.
You're going to have to mail copies to them.
So we can.
You're going to have to certify that you're mailing copies to them, or somebody will here. You're not going to do that now. But, and now we're going to
5373.
Case 5373, page 1, 7.4.
thank you.
Chief Code Officer Jocelyn Ramirez, case 5373, property owner Nicholas Suki, site address 3900 Southwest 52nd Avenue, Pembroke Park, Florida, Unit 202. A notice of violation was sent by regular mail on October 5th, 2020. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail March 3rd, 22, and posted to the property March 4th, 22. The violations were for installation of a wooden awning or gazebo without a permit, installation of a shed without a permit. At this current time, the owner has not obtained any permits. Therefore, I am recommending that this get complied in 30 days, if not a per diem of $50 and a $100 admin fee.
Based on the unrebutted testimony of the Chief Code Compliance Officer and the exhibits on file, all accepted into evidence without objection, I find a violation in 5373 and compliance within 30 days, or if not, there will be a $50 per diem plus a $100 admin fee.
Next case is 5375, that's item 7.5. In council, I kind of need your advice on this one. Chief Code Officer Jocelyn Ramirez, case 5375, property owner Enrique Roca Mora, site address 5100 Southwest 41st Street, Pembroke Park, Florida, Unit 220. A notice of violation was sent out by regular mail on October 8, 2020. A notice of formal hearing with a copy of the notice of violation was sent out March 3rd, 2022, and posted to the property March 4th, 2022. Violations were for plumbing defect in bathroom, unsanitary water pouring out of the faucet. Owner is to obtain a permit and inspections for repair. Next item is kitchen cabinets loose and overhanging. Owner had to obtain a permit and inspection for repairs. Next item is leak in ceiling of bathroom. Obtain permits and inspection for repairs. Infestation of roaches and mold infestation. Owners to remove those infestations and obtain a permit for the mold repairs. removal and repair. Obtain permit for and inspections for demolition of any drywall. So that being said, the property owner has been in contact with me and called a reinspection. I believe it was this week, right? When we did the inspection at Condado.
Oh, yes.
Yeah, this week. So I inspected the property. The owner had removed the mold, basically did a whole condo renovation, but he did the condo renovation without a permit.
Without a permit.
Yeah, I stated in item 1 and 2 and 3 and item 5 that he had to obtain permits for any repairs. However, I didn't cite him on this particular violation for work without permit. So my question to council is, do I close this case out because everything has been fixed and cite him for work without permit on another case?
Yes, you may. Have a moment. I think it's a very salient question, actually.
I think so as well. Magistrate, what I would suggest actually at this time is that we proceed forward at least on these violations. Looking at the actual notice of violation, it says, again, repairs and installations that shall be made so to comply with the provisions of the building code. So they were on notice. Understanding that any work done without a permit is inherently unsafe. And also, looking at this, I don't know if it's requested by the town, but obviously we are dealing with health, safety, and welfare issues. Understanding that in this situation, the owner might actually be able to apply for an after-the-fact permit. That has nothing to do with what the hearing that's here today. As far as the violations, with the inspection as to a lot of the issues, it would either be complied or not complied because it wasn't done in a workmanlike manner, given the actual specific violations, which are repairs and installations 5-105, which does require a permit, 5.5-2, which also in subsection 1 on the actual notice of violation also states requires a permit. So therefore, although they might have removed the health, safety, welfare, or remedied those particular issues, looking at the code that was particularly cited, they did not comply with that, given the fact that permits were required under the code that was given to them. Now, notwithstanding, again, some of the other issues that might or might not exist on this particular property, and notwithstanding any other future cases that the town may be able to bring, in this case, given the egregiousness of the violations, and also the fact that they still might be able to, again, and this is up to the owner, maybe they did it on an emergency basis, which is permitted under the Florida Building Code, but that's between them and their contractor on how they want to handle that, that we would still find the violations, given the fact that although the health, safety, welfare aspects have been complied, the actual code violation has not.
Yes, I've looked at the various areas of work which seem grungy or sanitary photos. I think that in light of the totality of the circumstances, the evidence of record accepted without objection, statements by the Chief Code Compliance Officer, argument of special counsel, considering all of that, in conjunction with the fact that the violator has not appeared today. This was duly served. I have a question. Did town staff ever lead the violator to think or ever agree with the violator that this would be closed out and that they did not need to appear today? To me, that's very important.
No. What I told the violator was that, the property owner, Enrique Rocamora, was that I have to look into the case and determine if he does or not have to appear, but I did state it to him that on the violation that he had to obtain permits for these repairs.
But you said something to me, which again, I don't mean to, but it just troubles me that you would look into this and decide whether he had to appear or not.
Right.
Oh, and I appreciate your candor, but does that mean that he was under the impression that he would hear from you about whether he had? I mean, I just, I'm very conservative about these
Yeah,
things.
and he came in yesterday, and we discussed it with the building department that he had to correct the violation still.
But was there any discussion about this hearing today?
Today, no.
But again, I don't want to misunderstand what you're saying or misquote you. Did you say to him at some point that you would advise him whether he had to appear or not? Yes, you may. No, you may. You may feel free to.
Okay, so I did not tell him he did not have to come. And
You did not tell him
I
that.
did not tell him that. I told him I had to look into the case. I looked into the case. He had to obtain permits. He came in yesterday. He was aware that there was a hearing and that we're still going to proceed with it.
In light of that further explanation, we can continue with the case. What do you recommend? I mean, I just never
Because-
want, I never want.
Right, yeah,
I
yeah.
never want to proceed in a case if anyone is under a misimpression or some impression that they did not need to be here. I would continue that case, you understand? That's
Yeah.
what I would always do. Give them a chance to either show up or not show up, but when they clearly knew they had the right to do one or the other.
I'm not sure why he showed up. I can't speak for him.
But no, what I'm concerned about is him not showing up today.
Right.
And did anything that the town do lead him to think that he
No.
didn't need to show up?
No.
Okay, then we can, okay.
Because as council stated.
Right.
Yeah, as
You don't-
council stated, he corrected the health and safety, yes. But the permits still needed to be pulled and that was made clear to him. And it was reconvened, our discussion was reconvened yesterday with the building manager. He was aware he still had to comply with all the violations of the permits. So my recommendation,
Yes?
because
Yes.
it
I'm
seems,
waiting
it
with
seems
bated
like,
breath.
it seems like he just found out that, I told him it was on the violation, I said, but for him, it's like brand new. And he did do a great job. The place looks great. So I'm gonna recommend 90 days, because he has to pull a permit, obtain plans, and it's gonna take him quite some time. He can also request an extension. He did mention to me that he purchased this property on a foreclosure, and there was a tenant living in there in those conditions for a whole year. That tenant wasn't paying rent for a whole year, and he couldn't evict that tenant because of the
So it was a
pandemic.
holdover, it was a tenant that suffers or a holdover tenant or
Right.
something. All right, that doesn't matter, okay.
I just
So,
want to state
yeah.
for the record that what he mentioned. So he couldn't evict it because of the pandemic.
But you don't have to
hold on
testify
that.
for him either. I just.
No, I'm
you
just,
know,
I'm testifying the
look,
conversation that I had with him.
Right, okay, no, that's fine. Right. The important thing to me is your representation, that you did not tell him or lead him to believe that he didn't need to appear today.
No.
And
I
no
didn't.
one gave him the impression that this would magically go away or anything like that.
Correct.
Okay, So go ahead with what you were
So,
going to.
as I said, I recommend 90 days
Yes.
and a per diem of $100.
100?
Yeah. With a $100 admin fee.
Based on the evidence, unrebutted, accepted into the record as shown in the file, the officer's testimony, clarifications, argument by special counsel, clarifications by the code enforcement officer, I find that there is a violation as charged. In case number 5375, I am entering an order providing for 90-day compliance, and if no correction is achieved within that time, there will be a $100 per diem fine, as well as a $100 admin fee, which is hereby imposed in the order. Thank you.
Okay, the next case is on page 4.
Yes. And what number might that be?
Item 9.1 and case 4475.
4475. Thank you.
Chief Code Officer Jocelyn Ramirez, case 4475. Property owner, Pembroke Park Warehouse Holding. Tenant, Neville Shepherd. Site address 3120 Southwest 19th Street, Pembroke Park, Florida. Subject real property 3140 Southwest 19th Street, Bay 658. This matter is here today for confirmation of fine. A notice of hearing to confirm fine was sent out by certified mail on March 3rd, 22, and posted to the property on March 4th, 22. The confirmation of fine, which includes the $100 admin fee, is $46,400.
Anything else you
And
want
we're
to say?
confirming the fine. No, nothing else.
Based on the unrebutted testimony of the Chief Code Compliance Officer and the evidence on file, including the prior order of which administrative notice is taken and all exhibits accepted into evidence, in case number 4475, I am entering an order, supplemental order confirming the code enforcement lien, making the findings of fact contained therein, and confirming this fine at $46,400 for the town to record and consider enforcement in any manner allowed by Florida law. Thank you.
And that concludes all my cases.
Page 3, agenda item 8.4, case number 6723.
Yes.
I am Code Officer Richwagen, representing the town of Pembroke Park.
Yes.
The property owner is 3133 Southwest 25 LLC. Site address 3133 Southwest 25th Street, Pembroke Park, Florida 33009. They're in violation of operating without a business tax license. Also, there was a loading ramp that had been demolished without a permit. The parking lot or parking area was being repaved and new asphalt was being added without a permit.
Right.
The notice of violation was issued on 2/7/2022. Delivered regular mail 2/7/2022. Notice of formal hearing was posted on 3/2/2022 and certified mail on 3/2/2022. Sorry, certified mail on 3/1/2022. My recommendations is 30 days with a fine of $100 with an admin fee of $100. At this time, this concludes my testimony.
Noting, again, for the record, absence of the respondent, the evidence in the record, in the code enforcement file, all accepted into evidence without objection. And the testimony, I find that there is a violation of the Town of Pembroke Park Code of Ordinances is charged, and the order having found such violations, will provide that there needs to be compliance within 30 days of the date of this order. And now, when you're doing the orders so entered, whoever's preparing these orders, when you enter them, like sometimes they're missing like little lines and things like this, but this one, I'm only mentioning it to you because this is sort of, okay, the spacing,
Okay.
there's barely room for the number here. So the number is fairly unintelligible because, I mean, you've left like 1 inch to put in the number. So, you may want to correct that today, now, or,
Yes,
I'll leave it.
we draft our own orders, so I will correct it for him right now. As he reads his cases, I'll do it.
It's just very obvious. Problem, look, bottom of the first page, okay?
Would you like me to proceed with the last one?
Yes, please.
All right, Mr. Magistrate, page number 3, agenda item 8.2, case number 6133. I am Code Officer Richwagen, representing the town of Pembroke Park. This is case number 6133. The property owners identified by Hallandale MHC LLC / Ralph Jean Francos. The site address is 3140 West Hallandale Beach Boulevard, Pembroke Park, Florida, 33009, Lot 516. They are found to be in violation of, there was a wooden fence that was installed without a permit. There was a concrete hardening and patio area, including the concrete stairs were permitted if not obtained from. So I'm trying to read.
No, that's fine, take
Because
your
this was
time,
from,
take your time. Don't, we're not, I mean.
Maybe Jocelyn's one. I'm trying to read this.
Point 2?
Take a moment, we're not.
Can I take a moment?
Yes, you can, I'm not pressing you to,
If I may, Mr. Magistrate, it looks like that the violation here is for a wooden fence that was installed without a permit. There was a concrete patio, which the permit status was inconclusive. There was an addition of a mobile home, and with no permit was attained for that. Addition,
when we look
as well
at
as
the-
prohibited outside stored items.
Right, so when we look at violation for 6133, I guess,
And if I may, Mr. Magistrate?
right, when we look for 61, right, yes, thank you.
Officer Richwagen, I know you said that this was from a prior code officer, correct?
Yes, correct.
Did you go out and inspect the property?
Yes, on the day the notice of hearing was posted.
And did you also confirm whether or not the fence was installed without a permit?
Yes,
And what was your findings?
no permits were pulled.
What about for the concrete slab?
No permits were pulled.
And what about for the addition in the back?
No permits were pulled.
And you did a search of the public records for the town of Pembroke Park and the applicable building permits?
Yes, I did for all three, as you just stated.
Thank you. And was there still accumulation of trash and debris around the property?
Yes, there was.
And are they, they are not in compliance today, correct?
No, they're not.
Okay, so what would be your recommendation as far as their time to comply and fine?
Allow me a moment.
Take your time.
Seeing as this goes back to 8/9/2021, they've had quite a lot of time to come into compliance. My recommendation would be no more than 60 days with a fine of $100 and a $100 admin fee.
And the date of compliance has passed, correct?
Yes, it is.
Thank you.
Refresh my recollection a minute. How old was this case? Goes back to August of last year?
Yeah, this goes back to 8/9/2021 when the NOV was initially, when it was initially written.
Had the town given any continuances before for compliance? Yes, and how much time did you give before?
For continuance, it would depend on their efforts. If they get it done,
I'm not being clear. Did the violator contact you and ask for more time in the past?
yes, they have asked us for more time, and they've asked for a continuance in the past.
In the past?
Yeah.
And how much more time did you give them in the past?
Normally, we continue it to the next hearing.
You did that in this case?
I'm sorry, he has to answer. I did not review this case.
So this was from a prior code officer. The NOV was left open. I took it over, and when I did the reinspection, I found that all these violations still exist.
Administrator, if I may. Mr. Richwagen, when did you take over this case?
I've been with the town for a little over 2 months, so I inherited it then.
Okay. And have the respondent communicated with you at all on this case?
I've received no correspondence from the tenant staying at this particular property for this particular case.
So what your testimony is that there might have been a prior continuance at the request of the respondent to the prior code officer? And at this time, are you aware of any additional time that was granted at the respondent's request prior to you joining the town? Basically, what
If
he
you know,
said.
if you know, right, if you know, I mean, that's all I was
No,
trying
no.
to get, right.
Has a respondent ever called the town and said, hey, I'm going to fix this, just give me another month, and then you hold the case?
They never responded or contacted me, so
Correct. Now, are you aware if they've contacted the prior code officer?
I am not.
So in light of all of that, the totality of all that evidence and the exhibits accepted into evidence without objection, you think that 60 days is, I was asking because the case goes back to last year. That's why 60 days is, you're comfortable with 60 days because I could see going 30 in this, but you're comfortable with the 60 days. That's all I meant. That's really all I'm getting at.
I'm comfortable with the 60 just for the fact that they need to pull the permits and to give them a chance to pull the permits, even though they did have a year because I'm inheriting it. I'm going to give them a chance to show good faith and give them 60 days.
Okay, fair enough. I understand your explanation, and that's all I was getting at. So, based on the testimony.
Mr. Magistrate, I do apologize for one update for the fine. Instead of $100 per day, because it's residential, I'd like to bump it down to $50 for the violation.
Is it's town policy to do $50 when it's
For residential.
Zone residential.
Yes.
And do you consider, I'm just for my edification here, because do you consider the mobile home parks to be residential?
Yes,
Okay, I'm just asking.
plus
Yeah.
low-income community.
Well,
Hold on one quick second. You could just give me a moment here.
well, to me, yeah, a single family house, whether it's low income or affordable housing or market rate, you know, it doesn't
Right,
matter. I
we-
mean,
we-
that's residential, but I'm asking you whether the mobile home parks, because they're sort of unique, whether they're considered residential or,
No, there's even more than that, that's why.
no, like under the building code, 3 units
Well,
or more.
I think this is particularly geared towards that specific lot. We're not, is the violation to that specific lot, or is it the whole mobile home park?
No, it's to the specific lot because the addition was done on that specific
Okay.
lot.
Okay, well, that answers my inquiry.
Trying to find.
Yes, that's fine. Go-
I mean, and it's not a town policy that is written down somewhere. It's a discussion we've had with our town attorney.
So
Just
if-
internal discussion.
If I may, I'm going to just kind of, may, Mr. Magistrate, kind of go where I'm thinking here. This is really just more for a question for staff, just so I can take a look at everything here. It looks like that we actually cited Hallandale MHC LLC, right, as the property owner. Now, normally under Chapter 162, the property owner is going to be responsible. However, there are, in the mobile home statutes, there's 3 very, very important separate statutes when dealing with mobile home parks. And specifically, one of the statutes says that the governmental entity is absolutely required to cite the responsible party for the violation. The next following 2 statutes, and I can look them up if you give me a few moments, specifically state that the mobile home park owner is responsible for things with the lot. The next statute is what is the actual mobile home park, the mobile homeowner is responsible for. So specifically, we have the obligation to cite the right person for the right violation, meaning that if it's dealing with the actual mobile home, the town is obligated to cite the mobile home owner.
And I understand what council is saying.
Okay.
And I was, you know, my frame of experience is more with condos, so I know that a city has to cite the condominium unit owner if they are doing things illegally within their unit, like additions or whatever. But if it involves the common area, so-called, or the, you know, easement area, whatever, you have to cite the condo association. I'm more, but I know that there are special things about laws about mobile home parks, which are
Right. Not knowing that this was a mobile home park, that's why I want to.
extensive in this town, and that's why you need to know, yes, we need to know, we all need to know if these violations are considered the mobile home or the mobile home park, because then we have to go back to the notice of violation and see who it was issued to.
Absolutely.
Yeah, so Mr. Magistrate and Special Counsel wants you to know that it will be for both the mobile home park and the lot because the wooden fence was installed without a permit. That's on the exterior, so that's for the mobile home park. The addition was added onto the lot 516, that falls on the tenant owner.
So you had to cite them both.
Yes, because
And who did you, right, so let's look at that. Who did you?
the property owner, Hallandale MHC LLC / Ralph Jean Francois.
So clearly, well, the property owner, and what I'm looking at is code enforcement notice of violation. The one I'm looking at, and I may be missing something, is sent to Ralph Jean Francois at this address. And then I don't, and I see another one sent to Hallandale MHC LLC / Ralph Jean Francois. So, no, feel free to look because we don't want to.
I'm gonna tell you, yeah,
But
this
it
one-
seems to me that at least palpably on the face, it seems that they cited each. Me, but please
then
feel free to weigh in.
Even with that, then we would also need to at least properly apportion. Okay, if I may.
Yes.
And also because, and again, this is new for, I didn't have a chance to speak with Mr. Ramirez ahead of time, we've assisted some of our other clients with extensive litigation. So what I would like to do is avoid that litigation for you. 723.024, compliance by mobile home park owners, states if a unit of local government finds that a violation of a local code or ordinance has occurred, the unit of local government shall cite the responsible party for the violation and enforce the citation under its local code. A lien, penalty, fine, or other administrative penalty may be brought against the mobile home owner or mobile home for any duty or responsibility of the mobile home park owner under 723.022. So that's 723.024. That's the one that I said that we have to cite the right owner. Under 723.022, mobile home park owners' general obligations. A mobile home park owner shall comply with the requirements of the building, housing, and health codes, maintain improvements in common areas in a good state of repair and maintenance, and maintain common areas in a good state of repair and cleanliness, provide access to common areas, including buildings improvements thereto at all reasonable times, maintain utility connection systems for which the park owner is responsible, comply with the park rules and regulations. That's under the mobile home park. The mobile home owner's general obligations. A mobile home owner shall at all times comply with the obligations imposed by the mobile home owners by the applicable provisions of the building, housing, and safety codes, including compliance with all building permits and construction requirements for construction on the mobile home and the lot. The homeowner is responsible for all fines imposed by the local government for non-compliance with any local codes. At all times, keep the mobile home lot that he or she occupies clean, neat, sanitary, and maintain in compliance with all local codes. At all times, comply with the properly promulgated park rules, such as conduct themselves on premise, consent in a manner that does not disturb others. That's fine. Receive written approval from the mobile home park owner before making exterior modifications or additions to the home. And they have to, when the last one's vacating the premises, that was actually modified in 2020. So looking at that and reading that, understanding that, of course, that makes it as clear as mud. And through prior research, I can affirm to you that there's not a lot of case law on these particular statutes as far as going into details. So with that, as far as the obligations here for, at least I know I can take a look for the additions, anything connecting to the home and maintenance of the lot will fall under the park owner. We might need, as far as the fence, just to review that to make sure that it goes either under which particular party.
The issue that we're having here is also that is under one folio number, and they are a business as well. And they are leasing these lots.
Correct.
So
The statutes give them,
we're also citing them as a business, they're allowing their tenants to build without a permit, with no ramifications.
if I may, Mr. Magistrate, given the fact that we know that there's a violation that was here, I would also like to give Ms. Ramirez the opportunity to speak with Ms. Anderson on this. Also, in light of the fact that the recommendation was 60 days, I would ask that we at least continue this 30 days. Are you here next month or not?
Usually I'm here every other month normally.
Every other month, so
then-
you'll be here in 60 days.
All right, so then at least, then to continue at 60 days with the understanding that this would at least be the time to comply, or if there's any additional time to comply, that this 60 days would be taken into consideration. That way the case can come back before you in 2 months, and then at that point, the town can speak with Ms. Anderson, look at these statutes, and then make a determination on how they want to proceed.
I actually would like to proceed with the case because we have spoken with Ms. Town Attorney Anderson, and we have spoken to an attorney in Town of Medley, which handles multiple mobile homes. So they have advised us,
Okay, it's just.
the town attorney advises to always cite the property owner and the tenant because we're citing them as a business. And that's what we had discussed with Town Attorney Anderson, and she agreed with everything.
I think that in light of everything we've heard, what I think that, No, I'm also always mindful, you've heard me say, that I want to sound like a broken record, due process. These cases were duly noted, and they're not here today. So having said that on the record, I do think that, I'm not making any kind of pronouncements, but I do think that optimal best practice is having heard from special counsel and then conferring with the town attorney, which is what's most important, that in these things going forward, it would probably be helpful for clarity to try to, for lack of a better word, bifurcate. You have one order as to what's attributable to the, that's my offhand suggestion, what's attributable to the park, and another order as to what's attributable to the owner.
So you would like to separate the two?
Going forward, I'm not saying, again, they're not here. I'm very mindful of the fact that this was properly noticed and they're not here. And if Ms. Anderson, after, if Town Attorney Anderson, after consulting with you or speaking to special counsel, or both wants to do something further, the matter can always come back in 60 days. But I think we've had pretty much a tutorial on, this. So, yeah, it's, the legislature, I know, treats mobile homes uniquely and has created all particular regulatory scheme for them, which doesn't make it the easiest for local governments.
Council, do you agree that we would also treat them as business?
At this point, I would have no further comment without speaking with Ms. Anderson. I would rely on her previous advice to you.
Okay.
That it's again, given my understanding of the statutes, I stated I wanted to make you aware of their existence.
Right. I am familiar with those statutes. But again, there are business statutes too. So, if you guys, if Mr. Magistrate, if you would like to reconvene in 60 days, we can do that as well.
Well, I'm not, again, you've heard me say in general, and anyway, we're on the record here, that I'm not one for, bringing back orders needlessly. There has to be a finality to these things, I mean, I don't like to be questioning orders just for, if after conferring with your counsel and considering this, your counsel thinks it should be brought back for some clarification, and that's fine. Otherwise, enter the order today. We've had a discussion about this. You're aware of it. And I only brought it up because I was thinking of the whole business about the analogy to the condos and the common areas and the private, and that's it, So what is the recommendation?
I would still consider the recommendation of 60 days.
And
with the fine of $50, with the admin fee of $100.
Okay, based on the unrebutted testimony, the evidence on file, which is all admitted into the record without objection, we're going to have a compliance within 60 days, and we're going to have a daily or per diem fine of $50 per day thereafter if full compliance has not been achieved, and the $100 administrative fee as customary for every case. The order so entered does provide for these violations and these stipulations in case number 6133. And, I've said everything else I wanted to say about it. There's nothing else to add. That's what the order provides. And this order, along with everything else, will be mailed out. And in this case, one copy to each, one to, you understand? Yes. And is there anything else to come before the magistrate this afternoon?
No, Mr. Magistrate, this concludes all agenda items.
Ramirez, is there anything else?
Nope.
Okay. Is there anything else to be corrected or, further?
Nope, not at this time.
Okay. All right. So on that basis, we stand adjourned.